11 போட்டியா 11 போட்டியான்னு கோட்டான்னு போட்டிருக்கான் அதுதான். தெரியல. என்ன யார் பேரும் சார், யார் பேரும் தெரிஞ்ச பேரா இல்ல. சரி வந்து
number 1 to 6, page number 2, page number 7 to 21. Page number 3, serial number 22 to 31, 4, 32 to 40.
Request is the matter on 28th.
with your lordship kindly.
That request is the matter next week.
With your lordship kindly.
This week.
With your
Yes.
lordship.
Yes.
Serial number 47 may
Yes.
kindly taken up on Wednesday, coming Wednesday. 47.
47. Relist the matter.
Coming Wednesday.
Next Wednesday.
Coming Wednesday.
Yes. Yes.
Much obliged.
Page number 6.
Human psychology is a different game.
Page number 6, 52 to 62.
56.
List along with WP so and so next week. Counsel for petitioner to serve additional copies on counsel for the respondent. Just one. 30. I'd request list the matter after 2 weeks. Yes, Sanmati. Well, let us see what is the matter. Okay, now serve a soft copy immediately. We'll have it after 2 weeks. I'll give a date. Date 2 weeks. 5th, sir. Interim order earlier granted is extended. That income tax is it? Suzuki. Ah. Huh? 53. Release the matter next Wednesday. Interim order earlier granted is extended in the next. So appearance you want. A memo, memo for being spoken. Memo. Now council for the now council for the petitioner. Is now the memo for being spoken to and request for name of other council who also appeared along with the senior council to be mentioned in the order. In light of the submission made, the appearance of parties to be modified in terms of the memo. Accordingly, the order passed in WP 9783 of 2023, dated 24th May 2023, is modified accordingly. Must you not state in your memo, madam, whose name is already mentioned, whose name has to be mentioned? Look at your memo. No, just 1 minute. Just look at your memo. Now, your memo, you have said. Yeah, you have said mention the name of so and so. Now, senior counsel's name is already mentioned, isn't it? Only the other 3 names have to be mentioned. Yeah. Right, but one is the memo. Is that the memo? You sign this and give it. You sign no one. So immediately after arguing in these matters, you give a slip like how they do in the Supreme Court. In the format ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು appearing counsel ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ ಒಂದು ಫಾರ್ಮ್ಯಾಟ್ ಅನ್ಸ್ಬಿಡಿ ಯಾರು ಬೇಕೋ ಮಾಡಿ. Yes.
Well, my lord, serial number 2 may kindly be passed over.
Pass over. Commercial tax. Learned Counsel Sri M. Kumar, AGA, accepts notice for the respondents. We'll have it next week. Let him take instruction. Learned list the matter in the orders list for consideration of interim prayer on. Yes. Yes. ಇದು ಸ್ಕ್ಯಾನ್ ಆಗಿಲ್ಲ. The AGA Shri M. Kumar accepts is directed to accept notice for respondents 1, 2, 3. Now what has happened to the appeal? Let us look into it. Correct, as long as it's not altered adverse to his interest. One. And it can't go beyond the order of the tribunal. AG accepts notice for the respondent. This is the matter week after next. It is our next. He'll list the matter on Wednesday. Challenge the central tax. Non-counsel CH-11. Legality is directed to accept notice for respondent 2 and 3. Learned counsel. Madan Pillai is directed to accept notice for the first respondent. So let them have a look at it yourself, copy today itself. Relist the matter on Thursday in the orders. Yes. Just only. You appear for all the respondents. You can accept. Learned counsel Sri Sanmati accepts notice for respondent 1, 2, 3. Yes. 290. 20th. Now the request was made on. So without affording that, they proceeded. Wednesday. This is the matter in the preliminary hearing list. What in the preliminary hearing next week? What matters? Both sides are fairly of the opinion that can be disposed. Will have in preliminary hearing. Others will have in the orders. Yes, soft copies of the petition with annexes to be served by the end of this day itself. Yes. Yes, Hem Kumar. Hem Kumar is directed to accept the notice for the respondents. 1 and 2. Let him take instructions. We'll have it next week. He'll list the matter in the orders list on 22nd. 22nd. On the same transaction.
Same assessment here, same supply, everything. Super notice is also being issued by a second. I now being assessed by the state tax, it's not having. Central tax has rightly asked me to take a show on merits and not be money. But the kind of action are it's too early.
Now, who appears for the respondents now? 1, 2, and 7. 1 and 7. EGA accepts notice for 1 and 7. What about 2 to 6? The 5 and 6. 2, 3, 5, and 6. Learned Council G1 is directed to accept notice. Learned Council Madanand Pillai directed to accept notice for respondent 4. That was just one easier.
It was very much confusing. At the outset itself, at the endorsement, it's saying I have central tax. So cause notice is central tax. At every instance of the matter, brought to the notification and analysis. Despite that, he goes ahead. I can demonstrate before my lord how I brought it to his notice from the very first instance.
This point out.
Yes. My lord, may kindly see the first endorsement issued by the state tax office.
No, what is the now you are saying you are accessible only by the central tax.
Yes, my lord, may kindly first see annexure D1. My lord will see at page 123.
Yes.
My lord has that.
Yes.
That, my lords, is the screenshot of the GST portal itself. My lords, I just see the first column, third row, administrative office,
Yes.
jurisdiction center. That is the first, it's a primary, that cannot be disputed also. Then, my lords, the central tax officer on the following page, my lords will see, page 124. Annexure D2.
Yes.
At the top, my lords will see Government of India, Ministry of Finance, Department of Revenue, Office of Commissioner of Central Tax. So he starts the assessment for assessment year 1780. My lords will see the subject tax periods in bold, July 2017 to March 18. July is because that's when GST started.
Yes.
Then, my lords, I file my replies. I will not trouble my lords with that. My lords will straight away just go to Annexure H1, which is the first endorsement issued by the state tax officer at page 135. This is, my lords, will see by the state tax officer. My reply to that, my lords, will see at Annexure J1, page 139.
What is this endorsement?
That's an endorsement asking me to produce certain books of accounts. My lords will see my reply, first reply at page 139 at the bottom. We would like to also inform you that we have submitted the 139 just above the signature in the email. We would also like to inform you that earlier we have submitted above details and documents to the CGST audit authority for purpose of conducting audit for the said tax is yet to be concluded. Then, my lords will see statutorily an intimation came to be issued by the state tax officer at page 142, Annexure K. Because as such under GST law endorsement, there is no document for that, but he issued an intimation in 142, at page 142. It runs to about 27 pages. And my reply to that, my lords, will see at.
So now, correct. So now the proceedings by the state government have to be stayed.
Yes. This last document, my lords, will kindly see the stay order in similar circumstance, Annexure R, page 218. What has it?
Yes.
219 as a statement. That's where the order is passed. Shri so-and-so learned senior counsel of the petitioners heard on grant of ad interim prayer. Learned senior counsel submits that the petitioner has questioned the jurisdiction of first respondent to issue the impugn notificated small. At that time, they challenged the so-called notice itself. The petitioner is subjected to audit by the second respondent, Commissioner of Central Tax, in the light thereof. The first respondent could not have assumed jurisdiction, and this would be indisputable in view of provisions of 6(2)B of the Karnataka Goods and Services Tax Act. The learned senior counsel further submits that where similar questions are raised. The court has granted interim order. He refers to the order passed in WP number. I've also
Yes.
brought that.
Yes. Now we'll have to state. You file it and grant a limited. Yes.
And this 205, I replied to the intimation, I was just coming to that. I said, you would also like to inform that you have submitted the documents for jurisdictional GST authority and along with assistant commissioner central tax and support. First point in my reply to the intimation.
Yes, let us,
And that is all, that is before the show cause, again to the show cause, again I have replied.
which is that, let us, file your objection. Which is that other imprimatur in the connected matter?
Picture R, madam, page 218.
Let us, no, so you place it on record and then we'll modify the imprimatur. Yes, yes. The counsel for the petitioner submits that it is the authorities of the central government which have jurisdiction, as is evident from annexure D1. It further submitted that the petitioner has replied to notices issued by the Department of Central Tax Union Government. He submitted that simultaneously state government has initiated proceedings which overlap with that of the central government. Reliance is placed on imprimatur passed in WP 8467 of 2023, which reads as follows, page 219. Next. Accordingly, in light of the contention raised and subject to further consideration, there would be stay of
Picture A and B. B is a recovery notice. A,
annexure A.
I guess is one subject. Annexure C is the show cause notice for the central tax. That matters, I'll file my reply to that because that's on merit. But let no order be passed, that's all. Because if an order is passed pursuant to that.
Correct. Now, the interim relief is only against the state.
I sought for C also, but that may not be correct to ask for C of both. Annexure A, Maharaj.
Of annexure A in the next date, the respondent state is at liberty to seek for modification of the interim order upon filing statement of objections. Other respondents to complete their pleadings within 2 weeks. Yes.
Liberty to file my reply to annexure C. That is the show cause by the central. I can't ask for state.
It's clarified that insofar as proceedings by the central government, the proceedings could continue. So, could continue.
3.
By respondent number 3. Yes. Now the obvious has to be reiterated is what they want to tell you. Yes. Yes. Next. Yes.
148 AG order has been passed without considering my reply. And also not considering the return which has been filed.
Now to the notice under 148 AB you have replied.
I have replied. And my reply is found in page number 39.
This one. Now who appears? Learned counsel Sri Sushal Tiwari accepts notice for respondent 1 and 2. So you replied to the 148 AB notice.
Yes, sir.
Annexure?
Found in annexure D, page 39.
Yes.
D order notice can be found in page 29. Annexure D. And particularly in page 30, para 4. It says, however, the assessee failed to submit any further response and give details in respect of the transaction mentioned in the notice AB.
Paragraph
Paragraph 4.
4. So 148, capital A, small b. What was the reply that you filed?
Yeah, that's it. Yeah, the issue in again, there was a sale of property. The assessee received as a result of joint development agreement. As per the ruling of this court, as confirmed by the Honorable Supreme Court, any consideration received as a result of joint development is taxable in the year in which the joint development agreement is entered. In this case, that was entered in assessment year 2008-9 and not liable for tax for this year. And that is the reply I have given. So, consequently, even on limitation and jurisdiction also, there is no case for the department. If at all there is taxable, something is for 2008-9.
Now go to their 148 AB notice.
That's it. It is in page number 35 and details are in 36. It is seen from the para 2 I am reading. It is seen from the record that you have not filed return of income for the assessment year under consideration. As per the details available, it is observed that you have sold an immovable property for consideration of 2 crore 30 lakh, for which the buyer, Ms. Sandhya Suresh, has deducted TDS under section 194 IA of rupees 2,30,000. You have not offered the same and no return of income is filed for the year under consideration. The said receipt. Even the assessee has filed a return also. Also, I have enclosed in page number 34. So he does not even notice the filing of return.
Which is that judgment you are relying on?
I am relying on TK Dayalu. Okay. In page number 71, that's it.
Annexure?
Part of the reply, page 71. Part of the reply to arrested B.
Yes. So it should be accessible in the year of
Joint development, registration of joint development agreement and handing over of the position which happened in the assessment year 2008-9.
that is. Now, why you have not considered it at all? Well, state you take instruction. Huh? Yeah, I'll have it. No, but stay prima facie case made out first. How can you say, and why in this 148 AD you are not taking any interest? Your officers think it's routine. That's not how I've interpreted. Though it's procedural, according to me, it is substantive. And unless there's application of mind, finding you cannot reopen as you are doing it now. Learned counsel for the petitioner submits, despite having filed the reply to the notice under 148 capital A small b, the order under 148 capital A small d has been passed, observing that no reply has been filed. Subject to further consideration, there would be stay of 148 notice
Notice at 148 order.
of annexure A and B till the next date. Liberty is reserved to the respondents to file their statement of objections and seek for modification of interim order. This is the matter week after next. Now, in case it is you want it to be remanded, you make a early mention after getting instruction. We'll dispose it of, keep open contention, let them consent. Yes.
Ten and 12 are same as the two different assessment years. 10 and 12. 10 is assessment year 2019-20 and 12 is assessment year 2016-17. Allowed the information basis which these two assessments sought to be reopened is the same as information in 1890, where registration number identified. Identical information, just a cut copy paste.
That is a subject matter of consideration in some matter, other matter.
We have filed a writ petition for 1819 and this is the order passed below. Identical information.
No?
Just explain what the case of the revenue is and what our case is. Quite simple. The case of the revenue, my lord, is that there's some investigation going on in Hyderabad against certain parties. And some of them are my contractors. They say they are subcontractors, which I have denied they are my contractors. And some are not known to me. So basis that information, my reassessment is being sought to be reopened. I have filed a reply saying that they are not my subcontractors, they are my contractors. I have given them the contract. It's the contract, this is the work done by them. These are the payments that I have made. And in any case, none of these payments I have claimed as an expenditure in these years because these are for expenditure incurred for building the second runway in the airport and for Terminal 2, which recently got inaugurated. So in all these earlier years, I have not claimed any of these expenses as expenditure. So there cannot be any income escaping assessment, especially in those years. That was my simple reply. Now 148 AD is passed saying that those parties are not responding, therefore we.
So then the same interim order. Land Council Shri Tiwari is directed to accept notice for respondents. The Senior Council appearing for the petitioner submits that insofar as the assessment year 2018-19, the information on the basis of which order was passed under 148 capital A small d has been challenged, and there is an interim order passed in WP 8469 of 2022. It is submitted that the present, we can club the other two or no? It can be clubbed.
Yes.
That in the present matters also, which are pertaining to the year 2019-20 and 2016-17 on identical information, order has been passed under 148 capital A small d. Next, there is the interim order passed in WP 8469 of 2022, which reads as follows. Next, accordingly, in the present matter also, there would be an interim order of stay of further proceedings pursuant to the notice at annexure in both the matters.
In 2019, that is number 10, and annexure F in number 12.
Annexure E in WP at serial number 10 and annexure
Yes.
in WP at serial number 12.
Yes.
Then the last paragraph that
That
will
investigation against those parties can go on. We have no.
clarify that insofar as investigation relating to transactions of companies and entities referred to in the order under section 148A.
AB is the information. That information is basically given by the Hyderabad unit.
No.
Investigation is being done by the Hyderabad unit.
For the purpose of the interim order, any investigation relating to transaction of those companies and entities referred to in
Order under 148A, my lord.
referred to
Information also.
referred to in the notice under 148 capital AB and order of 148 capital AD are kept open. One first seal number 10 is clubbed with seal number 12 as the petitions are by the same SSC for different assessment years. The respondent is at liberty to seek for modification of the interim order if circumstances so made out on filing their statement of objection. Yes.
About the of course the tax funds filing next what we expect for it. So this one Deutsche Telekom
Serial number?
11.
Yes.
So the assessment year 2016-17.
Yes.
This is a challenge against the initiation of reassessment.
Yes, sir. Income tax. Non-council belief accepts notice for the respondent. Yes.
No, this is a case of fact.
Extra copy if you have.
Information. Krishna is a telecom operator based out in Germany. So far as Indian tax is concerned, it's a foreign company. As well as would know, between the telecom operators in India and telecom, there will be some sort of a understanding for interconnect facility. Meaning, if I were to make a call to Germany, my service provider's jurisdiction would not extend beyond the country. So what he would do, he would receive my call, put it into a hub. Then because of the interconnect arrangement, the petitioner sitting in Germany, his facility would receive the call and forward it to the intended recipient. This is how the international calls would come. But in this regard, the department called it as royalty chargeable to tax under section 916.
Yes.
A lot of petitioner has been resisting, and this is a legacy issue, a lot is going on from 2011 till 1890. This is an intermittent missing year. For all these years, this honorable court, including my lord in assessment year 1213, have granted stay. This is one missing item that has come up. What will notice at page 141. The assessment is 1213. Not will notice the second para there. Page 141. I've given several years on all the years the legal order. Then not will see in page 141. On the basis of interim order passed in connection 5159 of 2019 will not this grant stay. All these matters are connected. Same assessing, same issue, except that the assessment year.
What is the order, interim order passed in 5199?
5199. Let's get J.
As regards the same SSC, is it?
Traffic paid a lot. Traffic is several. A lot could be paid, at paid 142. It could be for several years. And paid 143 will not be fined. The further proceedings pursuant to the implement orders and the contempt notice are stayed until further.
So we'll tag it along with them and see.
Yeah, annexure A and B may have more than that.
Yeah.
Annexure A is notice under section 142. My lord will find it at page 89. Dated 19/4/2023.
And B is
Annexure B, my lord, is an order passed under 148 capital A within bracket small d, which is dated 19. My lord will find it at page 90. And it is dated 19/4/2023.
it is submitted on behalf of the senior counsel appearing to the petitioners that insofar as the same SSC is concerned for previous assessment years, including earlier
11/12 till 18/19.
11/12 till 18/19 in an identical factual matrix raising identical issue, interim order stay has been granted and draws attention to the order passed in WP 5867 of 22. And so, accordingly, taking note that as regards the same SSC interim orders have been passed in the present matter also, the interim order of stay of the order under 148 capital A D at annexure B and the notice under section 148 at annexure A and subsequent proceedings pursuant thereto. Respondent is at liberty to seek for modification of interim prayer if circumstances are so made out on filing of statement of objections. This is the matter along with the WP 5199 of 2019 and connected matters. Yes. Judge is deemed to know. Don't say your lordship knows. I don't know. I need not. I mean, I may not necessarily. Yes, next. I won't haul you up for contempt, bro. Yes.
All of them, yes, we have it 60,000. Okay. Yes, granted. Just to that cover.
Where the AGA accepts notice is directed to accept notice for respondent 1 and 2. Third counsel Madan and Pillai is directed to accept notice for the third respondent. Similar. Yeah. At page? Yes.
Please can answer the past 73 page number 73. Okay, correct. The input that is avoiding before disallowed. And demanded along with witness to another 50 and penalty 76 as under. So already passed an order. It is something as trading with the proceeding to recover the outstanding amount. How person of this particular order, somebody else already made.
The earlier order under 73 is a substantive. The substantive order. Substantive order under 73 is also required to be challenged, is what is. AG accepts notice. It is submitted that in an identical factual matrix, interim order has been passed in WP 8548 of 2022 and 1098 of 2023. Accordingly, taking note of the interim orders passed in the above mentioned matters, the recovery pursuant to the impugned notices dated annexure. Annexure. No. Annexure K is created subject to the petitioner depositing 10% of the tax as demanded within a period of 4 weeks. Yes. 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 You accept notice. Third Constitution Dilip accepts notice for the respondents. Yes.
And this is intimation which is generated, computer generated on automatic processing of tedious statements by the quarterly basis. And amongst others, various reports, there is one item of default over the page at page 35, my lord, at serial number 4. That is date filing fee under section 234E. And in the first limb, 4 small a, an amount of 55,400. Now, my lord, this pertains to financial year 1230. And similarly, all other annexures pertain to 3 financial years 1213, 13, 14, 14, 15. Respect of which this demand in an intimation under section 200 capital A is not permissible, but has been held by the division bench of this honorable court. Subsequently, that has been followed, and similar intimations have been set aside by this honorable court, and I have placed them at annexure E, F, and E.
Please take me to the division bench judgment.
Page 147, my lord. The 11th portion of the judgment, page 1, paragraph 23.
At page 151.
157. That's 147.
Paragraph.
Paragraph 23.
Read.
Three of the aforesaid observation and intimation, the acute intimation given by the respondent department against all the appellates so far as they are for the period prior to 1/6/2015 and the set as authority in the law. As the same can
No, but what is the reasoning?
is in paragraph 24, my law.
Huh.
The facts of the present cases are examined in the light of the first observation and intimation. All matter. The intimation given in purported exercise of power and are in respect of these under section 4D for the period prior to 1/6/2015. As such, it is an account of the intimation given making demand of the fees in purported exercise of power and section 108. The same as necessitated petitioner to challenge the validity of section 234E of that. In view of the reasons supported by experience, that the amendment made under section 200A of the Act, it has come into effect on 1/6/2015, had to have been prospective, to be having prospective effect. No computation of fee for the demand or the intimation for the fee, as section 234E, would be made for the periods directed for the respective assessment year prior to 1/6/2015, as the demand notices of section 200A by the respondent authority for intimation for payment of fee under section 234E can be set as without any authority of law, and the same applies and set aside to that.
Now, in the present case, the late fees with respect to which assessment years?
2014, 2014, and 14.
So this is all for prior to
Prior to 1/6/2015.
2015.
About that,
So shall we dispose it, give an interim order next week? Next week. No, but correct, what I'm just wondering, once the law laid down by the division bench has attained finality, then why do you go on with the exercise of 200A? Unless there is some ambiguity. Huh? Correct. So you may use AI tools and instruct if it has attained finality. If it is still open, it's a different matter. The Learned Counsel for the petitioner submits that the intimation raising demand by resort to power under 200 capital A as regards late filing fee under 234E for assessment years prior to 1/6/2015 cannot be resorted to in light of the order of the division bench in Pateraj Singhvi versus Union of India 2016 73 taxman.com 252 Karnataka. Accordingly, there would be an interim order of stay of
A1 to A4.
A1 to A4. List the matter in the preliminary hearing list on 22nd. Notice anywhere. Yes.
Your Honor, it's WP. Order was filed for the 2021. In violation of principle of actions, wherein for the Shuklas notice I had sought an adjournment. That adjournment refers annexure G.
Annexure
G. Page number 71, Your Honor. In a short time till 23rd September. But my request was not considered, and the option to file and reply to the Shuklas notice was put down. Subsequently, for that, I had sought to file a reply by an email in the Samadhan business assessment at annexure J, wherein I had requested to reopen that tab for me, file the reply. It was not considered.
Yes.
Then afterwards, an assessment order was passed on 26/9 at annexure A.
Of annexure. What do they say in that?
Your Honor, in the annexure A at page number 28. In the last tabulation form, in the last show cause notice dated 9/9/2020. They said reply is not received and no compliance.
Hmm. Yes. But annexure G is the e-filing details. Annexure G.
Annexure G, Your Honor, it's not by agreement sheet, right? It's a tab available in the portal, Your Honor.
That page. Yes. But this dashboard is
Your Honor, if you see the
now,
annexure G, it's dashboard pending actions, proceedings, new notices and adjournment details, Your Honor. At the top, right top.
now this is maintained by you, isn't it? This dashboard. They can upload, the SSC can upload. Yeah, is it? But this is under your control, this dashboard. Correct. And now you find out the veracity of annexure G. Correct. Now the dashboard, even as on date, will be available, isn't it? So check it out. We'll have it on Wednesday. And then we can open it from here, is it? No. No, I'm just asking.
Password and
Then let him show it to you and pass over. Let him show it to you. If at all it reflects. If it doesn't reflect, there's no question. Pass over. Let us see. You show it to me.
small question. Still, you know, the model is earlier than that. I apologize for not.
51. 51. You show it to him. Let us. Now this dashboard, the SSC can make use of for uploading. And then, but this is maintained by you. Then let us check password. If required, I'll adjourn, but let it prima facie let him show.
Number 154 of
A list along with list along with WP number
154 of 2023.
1154 of 23 on 22nd 22nd June. Which one?
55.
Same. 55 same one. Yes.
Consider it was filed on 6 annexure.
No, so you check it out. Yes.
Your Honor, my humble submission is it was not considered complete. My completion was made on 6/6, and they have passed the order on 10/3. 6B, my submission of.
Now, what is your request now? What was your request? What was your request?
I have submitted my submission, Your Honor.
Page 2. Yes. Point. Yes. No, it has been considered. Oh.
There is only one line submission. There is no identification of submissions which are made. I have provided all the evidences. And Your Honor, at page number 62, I had sought an adjournment. Then after I filed my reply on 6.3, wherein I have given a detailed submission, it is not in the it is not been considered in completely. There is no discussion on my submission. Just a one-line letter saying that it is in perused and it's not accepted. Doesn't make a good assessment order, Your Honor.
You can challenge in appeal. That you can challenge in appeal.
Your Honor, my humble submission can be sent back and they can.
You challenge in appeal. It's not considered in the sense that though you have filed it, they have applied their mind. Now that application of mind is wrong. It's a matter you must challenge in appeal. Take me to your response of 6.3.
It is at page number 66. 64 is the acknowledgement.
Page 60.
6. Your Honor, in this petitioner is an sales tax practitioner who collects money from clients and pays the commercial tax. He has submitted challans, all the details necessary to propose that the cash deposits were collected from the clients and then after forwarded to the sales tax department to potent payments.
Now, what is your finding on that, on this aspect? In the assessment order, just have a look whether it has been considered. Now, he's saying that those page 20. Yes.
It is not being considered.
Now, that you raise in appeal now. If you raise it in appeal, not in exercise of writ jurisdiction, you can't enter into.
One of my submissions consider it is not being discussed in detail.
What do you say regarding submission? That the only explanation he has given is all these deposits were that of the SSCs and it was not income of his own. That's all he's saying. That's the only explanation. That's your explanation. No, your explanation is that these deposits were that of the clients and it's not your income.
Not my income, but only the commission from which I've received, I've declared it. I filed my IPR for that.
Now, just one minute. Now the deposit amounting to 58 lakhs 12,675, all of which are deposits regarding payments to be made on behalf of your clients. All of which.
All of it, only a few portion of it, which is commission, which I have declared in my IPR. That my IPR is a page number.
So then I'll have it next week. You just get instruction. If it is so, that if you is it something that could be accepted or there's something more? Let us relist the matter next Wednesday only on this point. Learned counsel for the petitioner submits that he has made out a reply on 6/3/2023, in which it is pointed out that the deposits are payments of his clients and is not income. It is submitted that in the assessment order, same has not been considered, and accordingly, without such consideration, assessment order has been passed. Relist the matter for the say of the respondents on 21 next Wednesday. Interim order earlier grant is extended till the next date. Have a look at it. If there's something complicated, I'll relegate it. Yes.
The first one is 148 AE. The notice on the 148, this has been recorded in regard to the assessment report to pay some cash.
Yes, income tax. Land council delete accepts notice for the respondent. Yes. What was the, you have replied to the 148 AB.
Like what 148 AE notice has been regard to the cash deposits and assessment has given the reply to that.
How much cash deposit?
13.
13.
So out of the sales, everything has been submitted, cash and all has been submitted with the reply.
So what is the order under 148 AD? Yes. Yes.
About income has not included in idea. Therefore, it is established that same has not been offered for tax for the relevant assessment year as per the provision of the act. There is an opportunity of being heard as per provision of 148 of income tax was provided to the assessment prior approval from the public authority. Wherein the assessment has given source as to why income from the above transaction do not be considered income chargeable to tax. Assessment was required to furnish reply on October 28, 2022 response to the while the response submitted that and here submit before the who said that total had 50,000 cash deposit only account respects sales transaction. Same has been duly recorded in the books of account and same has been declared in income tax and indirect tax. So please note that our turnover that year, but cash only exists 13 lakh.
Now this is within, now this is within time, is it?
Then, reply also be given to that extent. What is happened is, 148 notice also useful. The system 148 notice only to that extent they were verifying the cash deposit, how it is come. All the books of accounts has been verified. Coming to the annexure, F below. The annexure F as page 38.
Yes.
The following what one is the meaning, summary of information, evidence collected against him. So, second para I will be on that. So, assessing has not submitted the required details for the notice of 148, 128, 10, 22. Reminder letter was issued on 67, 22. Furnished the required details for work. Further on revision of record, it is that the institution Mumbai has shared the information from CIT and other agencies based on the report generated by CGC authority, wherein it is informed that Advanced Computer Mobile India Private Limited having PSC number so and so has engaged in generating providing bogus invoices for purchasing for passing fraudulent into tax credit without supplying.
But this, the information is only 13 lakhs. But the order you have gone on to something else, isn't it? Information was only 13 lakhs. But under one,
Notice issued on 22 to 2023. Wherein he has asked for the details, not been submitted. Yet even the next page format also to that extent, you can submit. Assessing was gathering the material and this uploaded within the period, short period, when you pass the order of the 147, read it 148 for dated 10/3/2023. Within a case, he has passed the order.
where is the 148 AD order?
That is connection CH number 30, which I read it. So it is only around 30 lakhs of people.
Now they've sought to now can you now your reassessment is to be limited only to this, or you can go beyond it? You can? You can go beyond it.
Given to the assistant, submit the document. Because all are brilliant transactions, assistant pay the bills from that. There is no input tax credit has been taken up. So I have enclosed the copy of that also. That particular person, which the.
What was the time that was given for you to reply? How many days was given for you to reply?
Was 20.
28 to 2023. And then?
Notice from 22 to 23. So, there is no opportunity to submit the document because I have
The counsel for the petitioner submits that as per the notice of 22nd February 2023, the time that was granted to file reply was only 28 to 2023, which was not sufficient. And further proceedings have proceeded on the premise that the petitioner has not replied. Taking note of the contention raised regarding violation of principles of natural justice, there would be an interim order of stay of prayer. There will be a interim stay of the demand in pursuance of the order passed under 147 read with 144 capital B dated 10/3/2023 of Annexure G in the next states. Respondents are liberty to seek for modification of the interim order passed upon filing statement of objections. Yes, next. Yes, Mr. Sheshachala, whether the reassessment proceedings can go beyond the 148 AD order. Now, suppose the AD order mentions some information is given saying that some 1 lakh amount you have not explained, and they hear the reply and then they pass an order on 148 AD. In the reassessment, can they go beyond this, or are they to be limited only to that? So even if the order under 148 AD doesn't. Yes. Yes. Yes.
And for the relevant assessment here or here. So when we go further, provided further, that is the second column. That the assessment or reassessment is related to any assessment here falling into the period of 6 years. And for the relevant assessment here or here, whatever is this subsection, depending on the date of initiation of that under section 132 or looking at execution of the section 138 as the case, then again. But the meaning is that if there are any assessment or appeals except for pending, aspect of the same will avail. The entire thing will be open and fresh assessment order will be passed, considering the old matter as well as the new matter.
Yes.
Now the problem here is not.
So in case of search,
Yes, sir.
then they can have recourse to 153A.
Yes.
However, in so far as for the same assessment here, if they come across some material and they are pending and the proceedings are pending for the same assessment here, for that particular assessment here of the SSC, and some material of search relates to the same, the pending years will abate because you are going to open it afresh. Correct.
Everything is open, fresh assessment order can be passed, and only one assessment order per year can be passed. That is how section reads, my lord. Now that has been concluded by this court, the division bench as well as the honorable Supreme Court. Now kindly notice here, my lord. Next year, read, my lord, page 18. Uh, First assessment order can be passed.
Yes.
Now, during the pendency of this assessment, that is in appeal, my lord, before the tribunal, there was a second check. There was a check on 3/4/2019.
Yes.
Now, the original assessment order, please notice at page 18, my lord, the original assessment order. Conclusion is at page 82. Total income is quantified at 4,80,19,1,100. Now, this appeal is taken before the tribunal. And subsequently, my lord, they pass a fresh assessment order at page 44, my lord. Please notice this assessment order, para 2.
Yes.
But para 2, assessment under section 143, section 153,
Now you are reading at page
page 44.
Annexure G.
Annexure G, para 2, madam.
The SSC as E-file.
Assessee has defined the original return of income under section 139(4) on 29/9/2020 declaring an income of 55 at 91,000. Assessment under section 143, section 143B was passed on 19/12/2016, assessing the total income at 4 crores 80 lakhs, which I just pointed out to the lord. Now concluding at para page 15, my lord, paragraph 15. What you got in para 15?
Yes.
Accordingly, assessment is completed by adding the above addition of rupees 4 crores 80,91,000 being assessed income under section 143 dated 19/12/2016. So what they do is they just add what was concluded in the original assessment. No, my lord, that is under subject matter of challenge.
Now this order and addition is pursuant to the search.
Yes, my lord.
So you are saying that the old one automatically abates by 153A,
Yes.
and this whatever material is taken in search must result in the
Fresh
complete
assessment. Only one assessment can be passed. Now, kindly notice what the Honorable Supreme Court says in this regard. This Honorable Court also has done that. At page 84, para 21 at page 114, relevant portion.
page.
Page 114, page 114, para 21.
Yes.
But if the submission on behalf of the revenue, that in case of such, because no incriminating material is found during the course of that, but in case of undertaken completed assessment, the AO can assess or reassess the total income, total income taken in consideration, other material is accepted. In that case, there will be two assessment orders which shall not be publishable under law.
Last,
Yes, sir.
as per the second proviso to section 153A, only pending assessment shall stand abated, and AO would assume jurisdiction with respect to such abated reassessment. It does not provide that all completed unabated assessments shall abate if the submission. Now, here it's still pending because it's in appeal.
Continuation of the.
Yes.
But what happens is, if not considered, my lord, that conclusion is drawn. Now the conclusion, they include it in my name. That is 4 crores and all. I cannot challenge it at all. No opportunity is given to me. Since the appeal itself abates.
Now we'll grant an,
Tribunal passes a consequential order. my lord.
pass an interim stay, you file your objection. Yes. Pending in appeal. Pending in appeal. Deep what? Yes. Yes. But then what is the meaning of the proviso under 153? Yes. Sir. Correct. No. So the question now will be whether in the understanding of the second proviso, when it says the assessment or reassessment pending as on the date of search, does it not include appeal proceedings? Because the assessment or reassessment has not attained a finality till the appeal is disposed of. If, according to them, logic is that you can, if it is pending, then the whole thing stands reopened. This incriminating material in the search must be taken as undisclosed income and addition made after explaining. So the logic is that since it's still pending, to avoid you can have one by consolidation. Let us see, you file a. Now, all of that will now have to be clubbed. The whole entirety of it will have to be reopened. And then single assessment order passed, including for search. But appeals are pending with respect to both as on date of the search. That point we'll see. Let us. You read para 21, let us see. At page 114. At page 114, you read the entirety of para 21. Just 1 minute. Just 1 minute. Yes.
This is what they are containing now, madam. It will become redundant. What is the purpose of having that provision? Because tax are
Let us see. No, we'll hear, correct. So you file your objection, we'll hear. So now what has happened now?
Only I am asking.
They have added it to the earlier assessment order.
Subsequent assessment of original conclusion, my lord, is added to the subsequent assessment order. No, I am not in a position to canvass my proceeding for the tribunal, saying that that is not taxable.
Senior counsel appearing for the petitioner submits that insofar as proceedings initiated pursuant to the search in terms of in search, comma, if assessment or reassessment proceedings are pending of the same assessee, same would abate in terms of the second proviso to section 153B. A. Second proviso to 153A.
Yes.
Reliance is placed on the judgment of the apex court.
ಒಂದು 7 months ಇದೆ ಕೇಳಿತ್ತು.
Case of
ಒಂದು 7 months ಇದೆ ಅವ್ರ ಹತ್ರ ಕೇಳಿತ್ತು.
adopt 2023 SCC online SC 481. In light of the same, there would be stay of
Further proceedings before the tribunal.
other proceedings before the tribunal pending in
Pending in ITA number 1184 Bangalore 2022.
pending in ITA number 1184.
The interim prayer it is there, para 26.
At annexure D. No, but now just clarification.
Yes, sir.
Now the in so far as the appeal proceedings are, you are saying we'll have to abate.
That's abate, my lord. Now the tribunal will say that it has abated and my release, I am not able to canvass for the first appellate authority. And the first appellate authority has no jurisdiction to remand the matter back. That's a problem, my lord.
It's the matter. Statement of objections to be filed within 2 weeks. Liberty is reserved to move for modification of the interim order upon filing statement of objections. Yes.
There is an adjustment. Clear here, when there is no demand. This refund has been pending for a year. Refund is determined for the service.
Request made on behalf of counsel for the respondent. List the matter after 2 weeks. Date could after 5th of July. Yes. Please give me the details. Now, what is the date of merger? What entity?
The next page number
Annexure?
1. The letter by the petitioner intimating the SC officer of the merger.
Now, which are the two entities?
But the non-existent entity is Urban Connected Services Technologies Private Limited. It merged with Urban Connected Services Corporation India Private Limited. Actually, page 21, Manoj Patel.
So this Urban Connected Services Technologies Private Limited, having merged, has lost its existence as per the which order of the NC what Companies Act. As per the approval of scheme in approval of scheme
Order is,
of merger on 13th November 2018.
yes, with effect from 1st April 2017.
With effect from
1st April 2017.
yes,
First paragraph
Yes.
of that letter.
yes, yes. Then what happened?
148AB notice about the country scheme. That is annexure page 76. Is issued in the name of the earlier entity, seized entity, Urban Connected Services Technologies Private Limited. The information at page 77 is that has not filed its for year 19. I filed reply bringing again the notice of the SC officer saying the company has merged and the merged entity has filed its. That is at annexure page 78.
So now, if at all, proceedings may be initiated against the petitioner as per law,
If law.
if law provides. That is the con.
What your lordships have said is already also.
Yeah.
148 AD and 148 notice both have been issued in the name of the city.
The petitioner. Urban Connected Services Corporation India Private Limited has called in question the validity of the order dated 30th March 2023 at annexure G, which is an order passed by the first respondent under 148 capital A within bracket small d of the Act, rejecting the petitioner's objections to initiation of assessment proceedings for the assessment year 2019-20 and has also sought for quashing of the notice issued under 148 for the assessment year 1920. It is pointed out that the notice under section 148 capital A within bracket small b was issued on 25/1/2023 as regards the entity Urban Connected Services Technologies Private Limited, It is submitted that the said entity is no longer in existence as on the date of issue of notice under section 148 capital A within bracket small b of the Act by virtue of order passed under section 233 of the Companies Act, whereby the said entity has merged with the petitioner company with effect from 1st April 2017. Next. Accordingly, it is submitted that the notice under 148 capital A within bracket small b and the order passed under 148 capital A within bracket small d and the notice under 148 required to be set aside. The lines is placed on the judgment of the apex court in the case of Principal Commissioner of Income Tax, New Delhi versus Maruti Suzuki India Limited, reported in 2019, 107 taxman.com, page 375, within bracket SC. Facts are not in dispute. The fact that the 148 capital A within bracket small b notice was issued to Herman Connected Services Corporation Private Limited.
Technologies private.
Herman Connected Services
Technologies private.
Technologies Private Limited, which has ceased to exist by virtue of approval of scheme of merger with effect from 1st April 2017. Peruse the order passed in wherein identical legal question was raised in WP 9594 of 2023. Para 9 reads as follows. Next. Accordingly, taking note of the admitted facts that notice was issued to a non-existing entity in light of the observations made by the coordinate bench at para 9, we produce above the notice under. Now, what is required to be set aside? The order at annexure G under 148 capital E within bracket small d and the notice under 148 at annexure H issued in the name of
Urban Connected Services Technologies private.
Government Connected Services Technologies Private Limited are set aside. Needless to state, authorities are at liberty to initiate appropriate proceedings as is open in law and permissible insofar as subject matter of the information as contained in the notice under section 148 capital A small b against the petitioner company if permissible in accordance with. Yes.
Order came to the task order number 2. That was challenged before the call number 3, my lord.
Scanner again. Yes.
That was challenged before the call number 3, my lord. They insisted for 20% statutory deposit. But that does not arise, my lord, because the petition hearing, my lord, is a great cooperative system covered by this honorable court, my lord. Your directions of ATP, my lord, agriculture credit cooperative society and will not fall under. But the statutory deposit of 20%, my lord,
Without para 3 first. Para 3. You have an next one? Which one? 1879. 1879. Page.
But that.
Now, what they are saying is, insofar as 80.
Only two additions. Page 32.
Page?
32. 30 is my appeal. 32. Taking only on two. He talks about the disorder additions made by the disorders of reduction under 80 and addition under section 68. My lord, this addition under 68, my lord, is deposited by the members of the credit corporation to the society, and that we have deposited by before the nationalized bank. We have no role to play. That is also covered, my lord. I can point it out. Let the record number 3 consider all these aspects and then pass an in order. In fact, the interim order was also passed, my lord, to not to insist upon the 20% taxes deposit and then go on with the matter. The interim order was passed on 18/12/2020, my lord. This is respond number 3 as pending that matter.
So then we'll keep contentions open and ask it to reconsider. So where is that application for stay now? No orders are on. That order has to be set aside and remanded back for. That is that order at page. Yes. But insofar as ATP, we can observe. The remaining, let it look into. Only ATP. The petitioner. That is not resolved, is it? ATP. Huh? Yeah, before the apex. The petitioner. No, so their only doubt is looking at the name. So that is the suspicion. So there's strong grounds for suspicion. He's elected once more or no?
Hello?
He's elected once more or no? This time he lost, I think. President who passed title last. Let us see. He was an MLA. He was. That's why I'm saying that is the ground for suspicion. No, I'm saying was the petitioner. has called in question the correctness of the order at annexure A as well as which is the assessment order, as well as sought for quashing of the notice at annexure B dated 20th February 2020, whereby the second respondent has ordered for deposit of 20% of the demand for the purpose of consideration of a request for stay of the demand. Counsel for the petitioner submits that the present writ petition can be confined insofar as the relief concerned insofar as annexure B is concerned. Next, it is contended that the order at annexure B is a cryptic order and the reliance is placed on the order passed in WP 1879 of 2020 to contend that insofar as the availability of benefit under section 80 capital P as the same is covered by the order of the division bench in ITA 5006 of 2013, the authority ought not to insist for payment of 20%. Insofar as other editions are concerned, it is submitted that the deposits made during the demonetization period are deposits of by the depositors which has been forwarded to deposits
Deposits by the members of,
has been forwarded to
the nationalized bank,
forwarded to the nationalized bank.
nationalized bank.
Other contentions have also been raised, and it is contended that the order at annexure B requires reconsideration with due application of mind. Next, for both sides, the order at annexure B is cryptic and requires reconsideration. While reconsidering, insofar as benefit under ATP is concerned, the authority not to insist on any demand in light of the order passed in WP 1879 of 2020. As regards the other aspects, the authority to hear the petitioners and pass orders in accordance with law after application of mind. Accordingly, petition is disposed of. Consideration is to be made by the third respondent of the concerned jurisdictional office. Yes. You do it on this one, so there was some very nice. Yes. Yes.
In love with another expectation 2966 that come up for your lordship.
Yes. This has been clubbed with
WP 2966 of 2023, which had come up yesterday. It's been posted to next week, notice was issued.
The previous an order has been already passed to the present. In the same matter, already an order has been. On? Their reading application at the time of the disposal.
So then we list this with that other matter. Serial number?
So they may be directed to give a copy of the.
Yes, yes. Now 33 notice must be issued, is it?
This and 33.
33 also. Serial number 23. Yes, income tax. And just one. Income tax, yes. Yeah, mention income tax. Yeah, you will accept notice. Income tax. Land council Sri Dilip. No, yesterday's matter, who took notice income tax? Dilip or who? Huh?
Not. Son.
Huh? Sushal. So we'll allow Land council Sri Sushal Tiwari. That you just check once, recheck. He directed to accept notice for the respondents. In serial number 33, list along with serial number 33. Serial number 33, same order. And compliance of office objections to be completed in WP 2944 of 2023. List 23 along with 33. And both matters to be listed along with WP 2966 of 2023. In 33 also, Land Council Sushal Tiwari right accept notice of the response. In office to put up impleading application stated to have been filed in serial number 33. Yes. Huh? Sanmati.
What happened was, we are an importer. Being an importer, the import value was already being subjected to customs duty, entire including the.
Just 1 minute. This is the first time it's coming, is it? Yes, Commissioner of Central Tax and GST. Land Council Sri G1 accepts notice. Land Council Sri G1 Niralgi accepts notice for respondents 2 to 4. Land Council Madanan Pillai is directed to accept notice for the first respondent. Yes.
Yes. What happened was, we are importers. We were importing cost and trade base. So value was a composite value. Customs duty was being paid on the entire 100.
You have an extra copy, you can give it.
And Milord, what happened? The respondents introduced this new notification by which out of this 100, they all further separated freight, started charging GST on that freight as service. We paid both, Milord. The customs also on the entire value, and again IGST on that very value. That separated. These matters, Milord, the petitioner thereafter challenged those notifications on the basis of double taxation, etc. That you are already charging the same goods to tax, including freight, and again you are separating freight and charge. The Honorable Supreme Court in Mohit Minerals held that no, that can't be done. The notification separating freight therefore held to be bad because they are charging a composite contract by artificially vivisecting, and it amounts to double tax. This Honorable Court therefore, Milord, in our own case, followed that and Milord directed the respondent to process our refunds, to consider and decide our applications in accordance with law.
That is the order dated.
Yes, that Milord, the last it is 8/2/23 annexure R. So there is no interim order.
Annexure R. Refund means interim order only. No, I'm saying for them, it should be disposed of like consideration of interim prayer. Page
176.
Let me just have a look. Page 170.
176. This is Milord, after this Honorable Court directed the respondents to consider whatever tax I paid doubly. That Milord will be considered here. The first point is, Milord, that they accept that the amount of tax that I am claiming as refund, I actually paid it in cash. That Milord will find at page 178. So that fact that.
Now, what is the finding of
Yes,
Mohit Minerals on this aspect which was accepted?
but on that aspect, there is no dispute at all.
No, I want this one.
The finding Milord said, Milord will find in Mohit Minerals have attached. Yes. Page 136, it is annexure G, conclusion 5, Roman 5. But not beautifully summarized by Honorable Mr. Justice Pardiwala, it has been accepted by the Supreme Court. Let me first show the short Milord, conclusion at page 130.
Yes.
Milord, the last one, Roman 5.
Yes.
Yes. The impugned levy imposed on the service aspect of the transaction is in violation of principles of composite supply enshrined under section 2 section 8 of the CH-11. Since the Indian importer is liable to pay IGST on the composite supply, comprising of supply of goods and supply of services of transportation, insurance, etc. in a CIF contract, a separate levy on the Indian importer for the supply of service by way of shipping line would be in violation of such. And this is the in sum and substance. In fact, on the previous page, Honorable Mr. Justice Pardiwala in Gujarat High Court recorded the submission of the SSC. That is, this would be the case then when goods are being supplied, packing charges would be separated, labor charges would be separated, there would be no end to it. Which Milord, the Honorable Supreme Court approved that you can't break the contract, and the contract main has already been suffered. Yes. Pursuant thereto, Milord, this Honorable Court, Milord, page 140. Annexure H.
Yes.
But this is my case. This Honorable Court, Milord, followed at para 5, page 143. The last 4 lines, Milord, under these circumstances, I have to consider opinion that the present petition also deserves to be allowed and disposed of in terms of aforesaid judgment and by issuing necessary directions to the respondent. And Milord, one of the directions was on the next page. After allowing my petition, page 144, Roman 2. Yes, respondents are hereby directed to consider the claim of the petitioner for refund of IGST amount paid by petitioner in accordance with law, bearing in mind the aforesaid judgment and observation made in the order.
in accordance with law as expeditiously and at any rate within 3 months of the date of the order. Now, pursuant hereto, I filed the refund claim amounting to 3.79 crore. 5 lakh will not I utilized it, therefore I have no claim. I am for the honorable court for 3.7 crore. The first aspect is which I wish to show to my lord is that there is no dispute that the amount of 3.79 crore was paid by me in cash. However, what happened in between? The respondents changed the method of your utilization of the credit ledgers. Your this amount of tax 3.74 crore. Your that comes with IGST ledger. But there was an amendment in law. What it stated was that whenever every month I have to pay the tax, despite the fact that I was before this honorable court challenging these notifications and therefore challenging the collection of 3.79 crore, it was appearing in my IGST ledger. The law came in between, where the respondents mandated that I have to use that IGST first before using a CGST and SGST. So the situation was like this, that 3.74 crore which I had kept separately, which I was not wanting to utilize, and this CGST, SGST which I had to actually utilize, but this IGST started without being utilized and therefore reduced, and this CGST, SGST started increasing because I had no use for it. So this was because of respondents' action. That despite my trying to keep it separately by their own portal, it was so mechanized that my amount in IGST, which I was contesting before this court, that will have got utilized. And why it got utilized? And if I would not have utilized it, I asked myself, then what would I have done? If I had not paid it in advance because of those June notifications, then C and S that would have been easily utilized, and this I would have become refunded. Now, as soon as the portal changed the methodology where per force IGST was used, like I immediately wrote a letter to the saying that I am before this honorable court challenging your imposition of tax. And now what the system has done is that my IGST is automatically getting utilized even though I don't want to. And I would ultimately be claiming refund. Therefore, the IGST is now turning into the shape of CGST and SGST, which remains unutilized IGST. That was in 2020. We will kindly have a look at that letter. That would find it at page number 66. But I say with reference to the above, we wish to inform that we have paid IGST and ocean freight under protest to the tune of 350, and in this regard we have filed a
Now the relief is in the same terms of the coordinate bench judgment.
No. Now, some water has flown after that. Since this shape has changed, IGST to CGST, Gujarat High Court considered the very same aspect and directed them that since you can't do it, the authorities cannot do it, they directed the authorities to correct their ledger, which was automatically flowing from I to C, and then grant the refund. That is the short point which is arising in this. Otherwise, tax stands there is no dispute. The amount has been utilized by the portal only after the date of this letter. That is also not in the earlier noted.
Is that judgment?
Yes. That is Radhesham 3.
Yes.
Yes, para 4. Exactly same fact. The last line in second page. In view of above, the ITC of ADSC and SGST started accumulating correspondingly. In such circumstances, as on date on account of such amendment in operation, the writ applicant have nil balance of IGST in its electronic credit ledger, and IGST balance is converted into CGST and SGST. In other words, the balance of CGST and SGST was artificially inflated as a result of appropriation of IGST credit. In such circumstances, the writ application is allowed. The respondent has directed to sanction and pay a refund of 3.27 after first reversing the entries of utilization of the subject credit and debiting the said amount from credit ledger.
Just have a look whether that last portion similar directions can be passed. That relist the matter on 28. In the preliminary hearing list on Wednesdays or Thursdays?
Wednesday.
Yes, on 6th of July. Notice ಹೇಳಿದ್ದೀನಿ. Yes. Yes.
Because there is a batch of about 15 matters that is already model has matters as well as well. Section about its financial color is the matter that is defined. These are all the matters that are pending around.
What is the interim order passed on?
134.
This is a fresh matter, is it? No, you appear for Union of India. Who are the other respondents? CH-11, CH Hemkumar is directed to accept notice for the second respondent. Central Board of Indirect Taxes. Learned Council Jeevan Niralgi accepts notice for respondent 3 and 4. Now, which is that matter in which some interim order is passed?
All matters there is an interim order.
What?
At 134, my lord.
Page 120.
134. This will be model, my lord, for the same SSC, but for the same branch. Subsequent period. Petition 1080. All for the proceeding, there will be an that was the bottom number. This was the case, my lords, where the order would have 5 years today, my lords, for notice. Some cases, my lord, in the batch of 3 matters, over some orders have been.
Lord Council appearing for the petitioner. So we'll stay the show cause notice. Lord Council appearing for the petitioners submits that insofar as the same petitioner is concerned for the previous assessment years on an identical issue being raised in WP 15251 of 2020.
That is the main matter. That is the problem.
No, I'm saying which is SSC's other matter.
10806 of 2012.
In WP 10806 of 2012.
2023.
10806 of 2022.
I'll explain that. I also have page number 63 about connection. Summary of statements. They rely on the previous show cause notice that has been issued. And basis that they issue the summary. And this is for the subsequent period.
So annexure A is the show cause.
So A, my lords will have at the bottom page number 63 grounds.
So here the still no further proceedings have taken place.
No, my lord. Grounds, my lord, page number 6. What statement has been issued for further period from 1/1/2020 to 31/12/2021. Based on the grounds relied in previous show cause notice number so and so, which has already been seen.
In the view. Interim order has been passed. Accordingly, taking note of the same, for the present and subject to further consideration, there would be an interim order of stay of the stay of annexure A. Respondents are at liberty to seek for modification of the interim order on filing statement of objections. This is the matter along with the WP 15251 of 2020, 15251 of 2020, and connected matters. Just along with the so and so. These matters
Good matters are in the final hearing stage.
in final hearing list after 2 weeks. Let us see.
Monday, there is the order communication that they have to proceed. I want to have to appear. Maybe IRP will come and
So let's adjourn it. Let us. Matter is adjourned. This one. Huh? So correct now. That which is a judgment. ಯಾವ್ದಿದು IBC code ಒಂದು ಹೇಳಿತ್ತಲ್ಲ. Correct. So what happens in extinguished? So you'll be treated along with secured creditors. So now what is to be done? So what is the legal position? No, sir. During the period of moratorium, that will be suspended. The right to recovery will be suspended. After that, correct. No. What happens is statutory due.
First.
So then we'll have to only adjourn it because the moratorium. Let us. No, I will just 1 minute. Annexure G. Yes. No, correct. Now, no, what I'm saying now, in the IBC proceedings, you must intervene and point this out so that in the resolution plan, I'm saying in the resolution plan, you must point out so this can take. But are you otherwise participating in these IBC proceedings or no? State and no, in other matters, you are intervening. In other matters, you are intervening. Counsel for the petitioner to file a memo and submit details of proceedings under the IBC stated to have been initiated. Such memo to be filed within 1 week with the advance copy on the state representative. Matter is adjourned. Correct. So you have an AI tool that will pop up as soon as there's some IBC one, wherever state. So you must have one software, it pops up that wherever IBC something is done, immediately the department must be notified. Huh? Yes. Yes.
Companies get into agreement with the petitioner by parts. Some of these clients of the petitioner are SEZ units located in SEZ. However, under the GST Act, in terms of 16 of the Integrated Goods and Services Act, any supply made to an SEZ unit, supply of goods or service to an SEZ unit, would be treated as what is called a zero-rated supply. Zero-rated supply, as the name suggests, the supply will be chargeable to tax, but at the rate of 0%. The reason is not different from the exempt supply. Exempt supply is the inputs and input services you receive to provide that. You cannot claim credit or not. Whereas in the zero-rated supply, you are eligible to claim the benefit of that credit and either get a refund of that. To ensure ultimately the idea now that for exports or for supply to SEZ, your supplies are competitive on a global level. Tax is not export, that is the underlying principle. So in this case, I supply rental car operator services to SEZ. The officer number in the order, he seeks to deny my claim for zero-rated supply by seeking recourse to the rules under the SEZ Act. He doesn't refer to the or doesn't rely on any provision as such under the agreement. And most importantly, now,
Rules under?
the SEZ Act itself. There are rules framed. the rules came to be amended in 2018. Because earlier on the rules provided were in relation to excise, the old tax regime. Now to bring it in conformity with the GST laws, the 2018 amendments came to use the words like supply, etc. as opposed to manufacture. That is under the old regime. Crucially, when this amendment was made to the rules in 2018, the sub-rule which the Subcontract is invoked was amended prospectively from 12/9/2018. Whereas the tax period involved was July 17 to March 2008. So on the face of it itself, it will not apply to these taxes. And over and above that,
The SEZ, the rules were amended
yes, on 12/9/2018.
to the effect, to the effect.
To the effect that when certain to the effect that when supplies of goods are made, which we didn't use supplies of services, goods supplies are made, then the SEZ commissioner, he has to endorse on those invoices and yes, the goods have been received. I will then have to produce that authorization, that endorsement before the tax authority for the benefit of zero-rated supplies trading.
According to you, even otherwise, this doesn't apply.
Yes. On three grounds. One is the rule of one invocation of the goods itself may not be warranted. The charging section under GST is supply of goods or services. Even assuming he could then invoke SEZ, two main policies that have been submitted now is that one, the rule is prospectively applicable for 12/9/18, doesn't cover it. And two, they are amended only to cover supply of goods. Supply of services is endorsement as such is not removed. The rules I have produced along with the petition.
And just show me the first zero-rated supply.
16 of the IGST.
Yes. Section 16.
Zero rated supply, subsection 1. Zero rated supply means any of the following supply of goods or services or both, namely A, is export of goods or services, that is not applicable, or supply of goods or services or both is within brackets for authorized operations. In fact, is like a stillborn amendment, not yet. That's I will not get to the number. Supply of goods or services or both to a special economic zone developer or a special economic zone unit.
Now here you are supplying to whom? Services to
a special economic zone unit.
That is to here in the present fact. In the present case,
Who's the SEZ unit? There are several entities that produce some sample invoices. Various companies are there, they need for transporting employees, etc.
yes.
So
Yes.
the eligibility to contribute the zero rated supply is fairly straightforward.
Yes.
I need to supply goods or services or both to SEZ developer or unit. In fact, that amended portion also for authorized operation, that was amended by the Finance Act 2021. But the provision in the Finance Act is yet to be notified. But in any case, I fall within authorized operation also.
Yes.
The SEZ rules are that produced with annexure G. Page 82. Annexure G is the rule by which the amendment came to be notified.
Just
Which have provided the rule as they stand now.
Just one. Annexure H.
Annexure H, page 95.
Yes.
Another kind of page 96. Rule 30 sub-rule 4.
Yes. What are these two? What are these two columns?
The left column alone is the rules adoption prior to the amendment, 2018. The right column, the third column alone is amended to 12/9/18. I just read now. A copy of the document referred to in sub-rule 1 or copy of the bill of export as a case with an endorsement by the authorized officer that the goods have been admitted in full into the SEZ shall be treated as proof of export, and a copy of such endorsement shall also be forwarded by the historical. They only say goods, whereas another kind is the sub-rule 31 and 32 on the previous page. There the amendment allowed to just put it in bold. The amendments were made to say supplying goods or services. And again, sub-rule 2, goods or services. I can also, in fact, just elaborate as to perhaps noticing, I don't know if it's an oversight or noticing the practical difficulty of endorsements. Circulars have also subsequently been issued under the SEZ law saying that if services are supplied to SEZ, then there's a mechanism which is sought to be done. That is also for 2019. That circular also produced and it's a T. Those are of course not even an amendment to the rule, it's circular. But anyway, again, that's perspective. And they're trying to come out with a system where if you supply a service, as a unit or the developer, how that is perhaps to be certified as having received by it. And in time, which can be forwarded for the benefit of the unit. My case, it is assessment year 17-18 prior to the amendment. First of all, I fit within 16-month definition. It is also for authorized operations because there's a letter to that effect. Then the rule is prospectively amended and more so only for goods.
Yes. Now what has happened?
Now, an order has been passed denying the benefit of the zero-rated supply. And the first respondent has passed an order saying it's not zero-rated. It is therefore a local supply, rather intra-state supply. So it's levying both federal GST and state GST on it, along with interest and penalty. By way of annexure A, Indian law. Annexure A starts at page.
A1.
A1, A1, 33. So the relevant findings are found at page 45.
Yes. Yes.
With respect to audit observation 1, I will read this one. On verification of the return, it is found the taxpayer has done zero-rated outward supplies of goods. Taxpayer needs to provide documentary evidence like DRC created. If zero-rated supplies is related to SEZ, then taxpayer needs to provide invoices authorized by SEZ commission. The taxpayer has not provided or uploaded any invoice duly endorsed by SEZ commission. As per SEZ Act Rule 30, Sub-Rule 4 of SEZ Code 2006, dated 19/9/18 for SEZ Act 2006. Further, a circular dated 12/9/19 specifies DTA services procurement form effective from September 18 or September 19, which specifies endorsements and duly authorizes the supply to SEZ. If invoice is not duly endorsed by SEZ commission is not certified, then the taxpayer cannot enjoy the benefit of tax or zero-rated supply tax. Hence, SEZ supplies will be taxed if endorsed invoice is not provided. Then, my reply is extracted. Is the officer's apprehension coming to the director that how do I know that the supply is being made go to an SEZ unit? Even assuming that you can revoke the rule, etc. That also not I produce certain invoices. When I give a same service, what's called a DTA, domestic tariff rate. SEZ is one unit and there are domestic, regularly, non-SEZ area. My invoice order will provide the GST-IN, the identification for the DTA recipient. I've also produced the GST portal website, which shows that he is a regular taxpayer. But when I do it for an SEZ unit, the invoice will mention the SEZ unit GST-IN and the portal website which shows SEZ unit. In this petition says that I can demonstrate. So even that I can allay my respondents here that where I have, and usually where I have supplied to DT, I have charged GST on, charged and remitted. And no demur about that.
This requires some consideration. That amendment, no. That is, you take instructions and fight.
So for one officer's order of the letter, there is no authorized or non-authorized variant. That's not borne out to the record. That is not the ground to deny. Secondly, authorized and unauthorized portion within an SEZ. Only we not know what can be done by that SEZ. The authorized portion of an SEZ, let's say it's an SEZ for IT and BPO service or anything, then only that can be done. The non-authorized operations are where we say DG sets are there, where you'll have security, you'll have banks. So that's a bifurcation under the SEZ Act itself. Into authorized and non-authorized. It has nothing to do with eligibility for IGS.
Now, now what is the stage of the proceedings now?
Order has been passed. Order has been passed. Where I supplied to non-existent. One annexer, one.
Okay, so now they are saying that this is a factual aspect that must be taken in an appeal. Why under writ proceedings is what?
Because one main primary ground, the rule which is being invoked, first of all, can SEZ rule be invoked to deny IGS? Secondly, that rule is admittedly prospectively applicable. Thirdly, that rule applies only to goods. On a jurisdictional aspect, the order itself is beyond jurisdiction. Everything else for us is accepted in the order. 6 issues were raised in the notice, 5 were being accepted. This is the only issue that's survived. And by denying the IGS, he has now treated an interstate supply or rather treated industry as an interstate. So it goes to the root of the matter. This is a jurisdiction issue that has to be answered.
The petitioner is called in question. The order passed under section 73 for the tax period July 17 to March 2018 at annexure A1, comma, is also questioned the impugned summary of the order for the period July 2017 to March 2018 at annexure A2, comma, impugned notice issued by the first respondent under section 78 at annexure A3, and I sought for a declaration in terms of the prayer at Roman 4. Next. Joint counsel appearing for the petitioner submits that the order that is passed rejecting benefit of zero rated supply as available to the petitioner under section 16 of the IGST Act is by relying on the rules framed. Which is, what are those rules? Page. Relying on the amendment made by virtue of the SEZ Amendment Rules 2018, which has come into force post September 2018. Post September 2018, we submitted that the period under consideration for which zero-rated supply benefit has been claimed is relating to July 2017 to March 2018, and accordingly, even if the rules were to be held applicable, this is a case that would not be covered by the rule. Various other contentions have been raised, including that the amendment confines the applicability to goods, and in the present case, it's one of services to which the amendment even otherwise would not apply. Subject to further consideration, noticing the contentions raised are also jurisdictional in nature. There would be an interim order of stay of A1 to annexes A1 to A3. The respondents are at liberty to seek for modification of the interim order upon filing statement of objections. Yes. 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 List the matter. When do you want? Yes. 20? Yes.
Yesterday I filed an affidavit stating that the offer of attachment is me.
Yes.
Ready to pay the amount. Because I have to receive so much of amount.
Yes. Affidavit kuru, affidavit.
I reached passing the law on 21/6/2022. And it's a few.
Yes, what is the affidavit? No, your affidavit.
Yesterday I filed.
Correct. So just read the relevant undertaking. Affidavit. Petition copy. Tax, correct.
My colleague has handed over. I will read you. Para number 3, my lord. I submit that without disputing the claim made by the respondents, I would like to state that certain amounts I have to receive from my client to the account attached by the second and third respondent. And due to the attachment of the accounts, the business of mine is almost closed. I further state that without disputing the claims made by the respondent 2 and 3, if the account attached by the respondent number 2 and 3 is reopened for record, I will pay the amount claimed by the respondent number 2 and 3 first from the amount to be received from my client, and then I will proceed to continue.
What we can do, Now what we can do, we can order the bank that whatever deposit that comes, that will be like treated as order of garnishee. Oh, please. Just 1 minute. Just. And this is under 83, is it? No. So on 21, 21/6. Next, we'll have it on Thursday and then dispose it of issuing directions to the bank. This is the matter on 22nd. 22nd. In the same stage. Yes. No? It is. Yes. Okay. So, when do you want? Relist the matter in the same stage on 28th. 29. List the matter on 28th. In the interregnum, no precipitative action to be taken. Yes. Matter refund. Huh? Huh. Let us see that. Now 2000 rupee notes are. Yes.
Even in my petition and in the letter.
In some matter regarding that gold which was seized, we had considered, isn't it? Last time. Huh? Oh. Section 132. Yes.
Provided further that such assets or any portion thereof as is referred to the first provision of the deed within a period of 122 days is taken. The last of the authorization for search under 132 or for acquisition under 132A as this is the case where in December of 2022 the entire cash comes to the seized. There is no assessment order passed, there is no liability against it. They made representation for the release of the money. Till today, my lord, no assessment order and neither has the cash been released. My lord, if there is a crystallized liability, my lord, then they are justified in reporting the amount. Without there being any crystallized liability, and my lord, what the letter said, I have not disclosed before. My lord, they are disclosed of all these transactions, all these money, my lord, my account by friend when I was in Dubai, start a business. I destroyed the source of all these accounts, partnership form, but that is the eventually, but otherwise, even other than the representation may be considered the type of management that to be disposed.
When do you want it to complete? No. Now the only question is, it's a legal question rather than factual. Now his argument is under 132B, second proviso, within 120 days. You will have to. Yes. No, so that you verify. In fact,
He wanted the crucial existing liability.
just, where do you get that? So correct. Now the your contention is that you can hold it till the assessment is complete. However, this if you look at the after the second proviso after the second proviso go to Roman 2. If the assets consist solely of money or partly of money and partly of others, the assessing officer may apply such money in discharge of the liability referred to in clause 1, and the assessee shall be discharged of such liability to the extent of money so applied. So it appears to indicate that as on that date, if there is any pre-existing liability, you can adjust. It's a question of law. Do your research and come back next week. Let us.
Hyderabad has taken a view for the I guess
Let us.
best of my knowledge, our court has not taken a view on it. I guess so.
Whether completion of assessment refers to ongoing proceedings or as on that date must have been completed, find out. Yeah. Yes. You're reading, you're reading. Read. No, correct. Now, you look at the legal position. If there is something, it makes the task easier. We'll have it next week. Relist the matter in the same stage on 22nd. 30. Yes. Yes. Relist. Huh? Who's that? The standing councillor? No representation on behalf of R1. Relist the matter on 22nd.
revision.
Yes.
C number 57.
Yes.
That is a simple matter pertaining to non-granted refund, non-consideration of application proceedings. Simple non-damage.
That is at 2:30, you make a mention.
Okay.
Yes. Which one?
Serial number 2, my lord.
No. Relist the matter. Next. Service tax. GST. Serial number 10, is it? Same order. You have the file. Correct. Whenever the senior says, you must say, I will not go because the judge will scold me. So you should, when you're asking for adjournment and asking for passover, you must come with the file. Now, sir, suppose I ask you something, isn't it? So you should say that instructions in this court are that only if I have a file, either passover will be permitted or adjournment will be permitted. So we'll have the same interim order. Put your file. Put. Can I again? AG accepts notice for respondent 1 and 2. Same order. Stay of annexure F. Stay of annexure F. Same as in serial number 13. Yes. Yes. Same order as in 13. Yes. So shall we?
I have a copy of that, Your Honor. It's in the slides.
Annexure.
Actually, A1 and A2. Consequential A1 and A2.
So you tell me the facts. Tell me the facts.
Your Honor, the assessment order of passed, wherein we have got an amendment on annexure G. Was not considered. Annexure G as page number 71.
From 16th to 23rd, you had sought for an adjournment. No, on 16th. Yes. Then go to the assessment order.
Assessment order is at page number 27. Actually,
So, but your objection you have filed, etc.
Your Honor, objection was filed to, objection was not, we were not able to file the objections because they had closed the tab. Even after seeking adjournment, they had closed the tab, we were not able to. Annexure J, there is an email. It's a grievance redressal email ID, wherein we had sought the
assessing officer to reopen that tab for us to supply, to submit the reply to the show cause notice. And we had, through this email also, we had submitted our reply. It is at page number 89 in the form of a PDF format, which is attached to the email.
So this annexure J is page 70, dated.
In that email, particular email is dated at page number 88.
No, just 1 minute. Now your request email is 21st September, isn't it?
Yes, Your Honor.
21st September 22.
Yes, Your Honor.
Then along with this, you have attached the.
My reply also, my Honor.
So where is that?
It has page number 89, Your Honor. It's a form in the form of a PDF attachment.
So along with that request, you had sent your response.
Yes, Your Honor.
That is attachment.
Yes, Your Honor.
Attachment, isn't it?
Attachment is on page number 89, Your Honor. Annexure, reply to SCCN, annexure 1, annexure 2.
The annexure J1, J.
Annexure J, Your Honor.
So along with this request, you had sent the reply.
Yes, Your Honor.
And then what happened?
It was not considered, and subsequently assessment order was passed.
Paragraph, which is that paragraph? No note, no reply.
It's at page number 28, Your Honor, in the form of a column. Tabulation form.
Yes.
At the
That
last
show cause notice. So from that stage. Now, for reply to show cause notice, as per annexure G, you had sought for an adjournment.
As per annexure G, we had short an
That is
adjournment.
in respect of the same show cause notice.
Yes, Your Honor.
The petitioner has sought for quashing of the assessment order under section 143 subclass 3, read with section 144 capital B of the Income Tax Act, dated 26/9/2022, along with the computation sheet and demand notice under section 156 of the Income Tax Act. Copies of which are enclosed at annexure A, A1 and A2. It is a contention of the petitioner that after show cause notice came to be issued, an adjournment, a motion for adjournment was made as per annexure G on 16 September 22 on medical grounds, seeking for adjournment till 23rd September 22. The making of such adjournment remains uncontroverted. Next. Meanwhile, the petitioner has also sent a communication seeking for an opportunity to submit reply in response to the show cause notice by email dated 22nd September 2022, along with the said request. A reply also has been sent by way of attachment. Stop. Such aspect is also not in dispute. Next. However, it is noticed from the assessment order at Annexure A, while observing that there was no reply to the show cause notice dated 9/9/2022, matter is proceeded with and orders passed. Next. The facts make out the case which requires interference in light of violation of principles of natural justice, insofar as respondent ought to have taken a reasonable view of the matter and taken note of the reply that was sent on 21/9/22.
Even 9/22, Your Honor.
22 while noticing 21/9/22 while noticing that the order came to be passed only on 26/9/20. Accordingly, the assessment order is set aside and consequential orders are also set aside. Matter is relegated to the authority, competent authority, to resume proceedings post issue of show cause notice dated 9/9/2022. Respondent to file a statement of objection, file is refile the statement of objections to the show cause notice and the authority to proceed thereafter as per law. Accordingly, if petition is allowed, is disposed of. Now, what is to be set aside now?
Your Honor, Annexure A, A1 and A2, and all consequential penalty order, penalty notices.
Accordingly, and the orders at Annexure A, A1 and A2 are set aside, and all consequential orders,
Penalty notices.
correct, it's all consequent, including penalty orders pursuant to the assessment order, are set aside. Yes.
Much obliged, Your Honor. Even P2, connected back to non-filing of returns is cancelled. Now, by virtue of the notification, we are trying to file application for revocation.
You just bring your Preeta. Just see what you can. Just.
Cancel application asking permission. In view of that,
No, you want 5-10 minutes? I'll pass over. I'll take it. Pass. I'll take it up. You have a mandamus. Mandamus. What do you say, mandamus? You were saying it's only a mandamus.
yes, both are.
Huh?
So what has happened is I filed refund applications. No acknowledgements were received. No proceedings were done. Neither were they granted. These are all pending refund applications pending from 2019. No actions have been taken, and suddenly on one fine day they recredit fees, input tax, without giving me any notice, no deficiencies.
You will have it on 28th. Release the matter on 28th at request of counsel for the respondent. Yes.
But the other similar matter that my development was into its 17014 of 2022.
You want it to be posted on
Yes,
a list along with the WP number
17014 of 2022.
17014 of 22.
Can we come the orders, or both are matters? Both are, one is service tax refund, one is GST.
Come attend the orders list. No, let that come separate.
Right.
But you move it
I,
in the orders list and tell at the club main big. Yes. Scan again. Previous. Yes. Page. Annexure B is page 31. Correct. 1 crore 90 lakhs. Yes. 38 lakhs. Yes.
balance.
Correct. Now, if you have to pay, you have to pay. Oh, no, that is. No, 20%. Correct. So 20% will record. That is the only amount that you have to pay. No, correct. That's on merit. Now, for the purpose of stay, you have to pay 20%. Once you pay 20%, automatically you'll get stay. We'll have it after 2 weeks, you pay and you move the matter.
According to section 2 weeks.
Correct. We'll have it after 2 weeks, you pay and move the matter. Unless you pay, how we can grant stay? No, because you will say, we thought you will pay within 2 weeks. You have not paid. You make the payment and move the matter. Let us list after 2 weeks. Yes. Yes, what is the matter? An identical term. The petitioner has an for setting aside of the order passed by the respondent, cancelling the GST registration at annexure F. After hearing the matter for some time, the counsel for the respondent submits that similar directions as in WP 3966 of 2023 can be passed and matter be disposed of. The petitioner it is submitted is a private limited company engaged in the business of security services. It is further known from the facts that returns were not filed within time as required for a continuous period of 6 months. And accordingly, the respondents have cancelled the registration with effect from 2/10/2021. Such order of cancellation is proceeded before this court. Next. This the coordinate bench of this court in WP 3966 of 2023 has disposed of a similar matter, taking note of the notification dated 31/3/2023, which enables a registered SSC whose registration has been cancelled under the provisions of 29(2)(b) or C of the CGST Act on or before 31/12/2022 and was not filed any application for revocation of cancellation of such registration within the time specified under Section 30 of the CGST Act to file an application for revocation in terms of the procedure prescribed. Accordingly, present matter is disposed of, reserving liberty to the petitioner to file an application for revocation in terms of the procedure prescribed as per the notification dated 31/3/2023. Accordingly, petitioner disposed. Yes. Yes. Annexure.
Assessment for the assessment of this notice, 16 February. Beyond 3 years from the end of it.
Now, is it beyond the extended period also? Uh,
Beyond the initial period. The information based on which this reopening is sought. Page 51. Page 50 onwards in the table. And there are several line items which total to 76. The amount is in half. I have made a reply. To separate and put the connection P. Now, the connection A to the order pass. Exposing of my objection. 148 day.
yes.
Possible. And on page 57, the concluding part of 19. Says the reply of the SSC has been reviewed and considered, and there are several bullet points which shares even as a point. But the first point is that the transaction value of the property involved exceeds 50 lakhs, whereas the income chargeable to tax arising out of the transaction is much less than 50 lakhs. My lords have very recently held suspect. What has to be looked at is not the entirety of the consideration, but the income chargeable to tax. Now, apart from that one item relating to the immobile property, there is salary of the capital gain is arrived at 35 lakh, salary of 11 lakh, and there is small another 6,000 all put together, it works out to 46 lakhs, 51,000.
We'll have it next week. We'll look into it, or shall we send it back for?
Add up the numbers. The result admits as my income. 35 lakhs of capital gain.
35 lakhs capital gain.
7 lakhs salary income. Salary income indicates as support periods. And another 6,960, 6,000, 7,000. 35 plus 11 plus 7.
Less than 50 lakhs.
However, what we say refers to the 71 lakhs in para 7 that we may look at in the above para. There is a last bullet point. The statement of income in this case is in the nature of asset above 50 lakhs.
Income he does not refer to at all. He does not even total and tell us what is the income that he himself already considered about. That's what he has not done.
Look into it and get instructions. Find out. Land Council Sanmati accepts notice for the respondents in the interregnum till the next day. There will be a stay of the notice at annexure A3. Huh? A1, A2 and A3 till the next day. Just look into it and see if it is. Now there's only one difficulty. Now suppose after in the reassessment proceedings, since in law you are entitled to look into other aspects also, maybe the SSCs feel that this 148 AD is only for the purpose of trying to see if there's some other material that may come out. But if you have to enter into that, your 148 AD must meet the requirements of at least prima facie satisfied. Let us relist the matter. When do you want? After 2 weeks. And they can at least henceforth take this 148D wherever possible little more serious. Otherwise, now series of matters are coming on. Yes. Let us.
After office of election, we
And counsel for the petitioner undertakes to legible copy of annexure D3. Accordingly, office objection is overruled. Petitioner further claims that he does not intend to claim any benefit of age proof. Accordingly, said objection is overruled. Yes.
matter further is 47 and the object. This matter may not 147. I filed my objections. The objections were disposed of without providing an opportunity. After 1/4/2021, 148-day procedure has been brought in, my lord. As for 148-day procedure, the assessing officer has to give me an opportunity of hearing, that is under section 148 AP, wherein this procedure has not been followed and directly my objections have been disposed of. For the short point, my lord, they have to provide an opportunity wherein I can tell the assessing officer what is my case, my lord. In this matter only.
So far as pending proceedings, 148A amended procedures to be followed.
Because
all pending proceedings, though initiated under the. You have to follow the new procedure. Next Wednesday, the Land Council Sanmati accepts a notice for respondents. Relist the matter in the preliminary hearing list on next Wednesday. Next day, 28.
Next. Pass out.
The interregnum, in light of the contention raised in the petition and submissions made, that the procedure under the amended section 148 capital A has not been followed, there would be a stay of
Say pursuant to
stay of proceedings
Pursuant to preliminary order entered post.
pursuant to the order at annexure L3. Petitioner is permitted to soft copies of scan ಆಗಿದೆ scan ಆಗಿದೆ scan ಆಗಿದೆ the petitioner to furnish soft copies to the standing council. The let us see, you give it for just only ಒಂದ್ಸತಿ ನಾವು ಕೇಳ್ಬೋದು ಅಕಸ್ಮಾತ್ ಸ್ಕ್ಯಾನ್ ಕಾಪಿ ಆದ್ಮೇಲೆ ಸ್ಕ್ಯಾನಿಂಗ್ ಎಲ್ಲ ಲೇಟ್ ಆಗುತ್ತೆ ಸುಮ್ಮನೆ ರಿಜಿಸ್ಟರ್ ಆಗಲ್ಲ ಸ್ಕ್ಯಾನ್ ಕಾಪಿ ಇದ್ರೆ ಕಳಿಸಿ ಕರೆಕ್ಟ್ ಅದು ಸ್ಕ್ಯಾನ್ ಆದ್ರೆ ನಾವು ಕಳಿಸ್ತೀವಿ ಸ್ಕ್ಯಾನ್ ಆಗಿದೆ ಪಿಟಿಷನರ್ ಬೇಗ ಎಸ್
Second objection is that the petition runs 200 pages. No volume should be made. In 2 days time, I'll make it. I'll do the deed.
counsel for the petitioner submits that copies have been served on the ESG. That that nomenclature is changed. Has been served on. Then is also the Solicitor General ESG Deputy Solicitor General. Accordingly, first office of the serial one number 1 is overruled. Insofar as office of the serial number 2, oral request of the petitioner to comply with the said office objection within 2 days is taken note of, and the same is kept in abeyance for the present, recording the undertaking that the same would be attended to within 3 days from today. Yes. So you will take learned counsel Sri Sanmati accepts notice for respondents 1 to 6. Sri Madanan Pillai is directed to accept notice for the 7th respondent. Relist the matter in the orders list on yes, in the orders list. This is the matter. We'll have it in the same stage and fix a date. We'll see on that. In the same. Huh? Yes. List the matter in final hearing list, date code, week after next. 5th of July. 12th July. Yes. Bill, in 39, I think that Ravindra Reddy is a Kalburgi editor. He appears for some of the authorities. Just wait. No, 1 minute. This 39, we had adjourned in the morning. Adjourned, huh? That council is a Kalburgi council. He appears there for these. Let us see. Let us next. ಏನಾಗಿದೆ? Yes.
Penalties for the focus issued under section 148 old housing. Next H 185. Dated 29th March 2016, it is beyond 4 years, other than 6 years. What kindly see?
Earlier limitation was?
Limitation was 4 years. It could have been extended to 6 years if there was non-disclosure on part of the
6 years.
6 years. Extendable to 6 years. 4 years was the limitation. Extendable to 6 years if there was a case of non-disclosure or non-payment.
Yes.
Our kindly see the section as it's at that point in time. Composite.
140.
It's 1.101
Yes.
Footnote number 60.
Yes.
I can see that old section 147. Escaping assessment if the escaping officer has reason to believe that any income chargeable to tax as escape is he may, subject to the provisions of compartment 1, assess or reassess such income and also any other income chargeable to tax which has escaped and the course of the proceedings under this section or incompute the loss or the depreciation allowance or any other.
Just, yes, or any other allowance.
Thereafter, so finally, see the proviso is important. Provided that where an assessment under the of section 140 or this section has been made for the relevant assessment year, no action shall be taken under this section after the expiry of 4 years from the end of the relevant assessment year, unless any income chargeable to tax has escaped assessment for such assessment year by reason of the failure on the part of the assessment in a return under section 139 or in response to a notice issued under subsection 1 of section 142 or section 148 or to disclose fully and truly all material facts necessary for his assessment for that assessment year. Section 147 has it shown at that point in time, the proviso said that reassessment cannot be done beyond a period of 4 years unless there was failure on the part of the estate to disclose to the, among other things. There was a written non-filing is also there, but
So just one incidental question, not related to this matter. So the department is contending that in light of power conferred to enter into an inquiry with respect to, once it is reopened, with respect to other matters also, the striking down of 148A orders should not be done mechanically. Now what they are saying is once it reopens, they have a right to look into other material also. Now here at 148AD, if you strike it off only on the basis of the information that is given, their right to subsequently travel beyond will be taken away. Some such argument.
no, that cannot be, of course. That's why it is very important that 148, the information, the provisional action that they take for the 148A procedure has to be very strictly looked at because reopening is a very wide power. It reopens a concluded assessment. Now, if they want to reopen on one point, that one point should be very, I mean, they have to make out the case that that information necessarily leads to escapement of income. Without that, that doors to reassessment cannot be opened. Because once it is opened, everything is open before it. Therefore, it is very important that that initiation has to be in accordance with law. If that's why Malad is Kelvinator as far as under the old provisions also. All that came and Supreme Court or first Delhi High Court in Kelvinator said that reassessment is an unbridled power that is given to the assessing officer. It reopens because degree assessment has to be necessarily concluded. It cannot be kept open for years together. It has to be concluded. Now, unless such power can be given only if it strictly satisfies the requirements of section 147 and 148. Therefore, it is necessary that that information should, and the inquiry, now earlier for this amendment, that was being done because of the order of the Honorable Supreme Court in detailed right, that was being done before the stage of assessment itself. Now that has been brought or legislated as well, provisions have been inserted, basically incorporating what Supreme Court said in detailed right, that this procedure, that invocation of has to be looked into. There are checks and balances also. Stage of 148B, AB, and the satisfaction has to be recorded by the commissioner at the stage of 148AD, satisfaction has to be recorded by the commissioner. There are more stringent measures that have been brought into the statute by the legislature. Therefore, it is not as if that because they have power to reopen other things, that this can be given a wide interpretation. But I would say the other way around.
Other way around. So you expose the SSC not only to the information that is not but to other matters also.
Correct,
So that's the reason why stringent procedure requires to be.
correct.
Yes.
I read that in the morning. I pointed that out. That explanation under the new provision provides for, and the old provision also said that once it is reopened, testing officer has power to go into things that were not brought to his notice at the stage of notice. If it comes to his notice during the course of proceedings, he can get into those other issues as well.
Read the explanation once more. No, correct. That is during the course of reassessment proceedings, after you have crossed 148 AD stage. Correct. That is in so far as such inquiry. Now, suppose under 148 AD, order is passed. You start the reassessment proceeding. During the course of that reassessment proceeding, you come across some information that was not a part of the information under. So for that, you can't insist. You follow again 148 AD, etc. So the explanation is in so far as that. Yes.
Basically says that reassessment cannot be done after 4 years unless there is failure on the part of the assessee to disclose fully and truly all the facts necessary for this. Now there are multiple grounds which we have taken in these petition, but I am asking on one ground which is squarely covered. This, like I pointed out, Manoj, the notice under section 148 very clearly is issued after 4 years.
What is the date? What is the
Assessment year is 2009-10. And if Malord kindly see the notice under section 148,
2010. So then 31st March 2010
was the end of 4 years. But the notice under section 148 came to be issued on 29th March 2016. That is annexed H, page 185.
29th March
2016.
So 6 years.
Yes. Within 6 years, but after 4 years.
Yes.
The law knowledge on this point is that where the reopening is after 4 years, unless there is an allegation in the reasons recorded that there is failure on the part of the SC and duly disclose all material facts, then the initiation of reassessment proceedings is added up.
That is any one of those conditions.
Any one of the conditions, there has to be allegation in the reasons recorded itself. Section 148 provides that reasons are recorded. Earlier, reasons had to be recorded before issuance of the 148. Those reasons which were recorded in the file of the SC officer before issuing the 148 has to 147, 148 notice has to necessarily allege that there is failure on the part of the SC to fully and fully disclose all material facts. Now, in this case, kindly see the reasons that are recorded, which my lords will get at annexure A, page 187.
Page
187, my lord, annexure A.
Yes.
Once the notice was issued, I had to file my return and ask for reasons. That was the old procedure as per I asked for the reasons, and these are the reasons that were given by the SC officer. By letter dated 25/4/2016. Kindly see the reason. The reason behind reopening of assessment under section 147 of the Income Tax Act 19 for year 910 is as below. The DCIT International Tax Circle 11 Bangalore by her letter dated had communicated that order under section 211 and 211A has been passed by treating the payments made by the SSC company to subcontract charges, but the same was treated as fees for technical services. For AY 2009-10, the payment made under this head was at all. On verification of the assessment records, it was found that the said, kindly see on verification of the assessment record, that itself shows that these payments were disclosed in the records which are available at the time of assessment. On verification of the assessment report, it was found that the said expenditure was not disallowed under 41A of the IT Act while completing the scrutiny assessment under section 143 of the IT Act. In view of the above, the AO had reason to believe that taxable income in excess of rupees 1 lakh has escaped assessment within the meaning of section 142 of the Income Tax Act. Now, these are the reasons recorded. There is no allegation in the reasons that there is failure on the part of the SSC. Disclose this fact of payment of fees so and so to Infosys China in the documents that are submitted for assessment. In fact, I have disclosed this. I don't have to go into it, but on the ground that there is no allegation in the notice itself, this reassessment proceedings can be set aside. If you not kindly see this question of the Bombay High Court, subsequently has been followed by our High Court also, because there is a lead decision on this point. Just first pointing out this decision of the Bombay High Court.
So, but they appear to state that the expenditure was not disallowed under 40A 1A. So now they feel that under the former observation regarding FTS, what you had considered, that can be reopened again according to them on the same, regarding the same amount, but on a different ground.
What the reason state is that I have made certain payments to Infosys China as subcontracting charges. Those have to be treated as fees for technical services
And tax.
and therefore I ought to have deducted tax. And because I have not deducted tax, they have to be disallowed under 40A 1A. In long and short, that is what the reasons state. Now, the primary material that is necessary for looking into whether this payment is required to be tax deducted or whether this payment has to be disallowed under 40A 1A is that I have made this payment to Infosys China. The fact that I have made this payment to Infosys China is borne in my financial statements and Form 3CP, which I am required to file while entering into transactions with my associated enterprises. All that disclosure has been there. I can demonstrate that disclosure has been there, and therefore the proviso is not satisfied. But before that, I am saying that the reasons itself don't allege that there is non-disclosure. That is one. And two, the assessing officer himself says that from the assessment records, I see that these payments are made, but 41 has not been done. Which means that assessment records show that these payments have been done to Infosys China. But you ought to have deducted tax, and therefore they ought to have been 40A 1A disallowance. Now that is an inference that the assessing officer is drawing. That is not a material fact. What I am required to disclose is only material facts. The material fact I have to disclose is that I have made this payment to Infosys China, which is borne from my financial statements. Now he is only drawing an inference. That is not sufficient for reopening under section 147, especially after 4 years.
The obligation is to disclose fully and truly
all material facts necessary for my assessment. And this is a case where 143 regular assessment was done. 40A1 disallowance for non-deduction of tax and everything has been done. Now that testing officer who did the regular assessment did not think that this payment tax had to be deducted, and therefore because tax has not been deducted, 40A1 disallowance had to be done. That testing officer did not come to the conclusion. How?
This aspect has been adverted to in the assessment order.
No, not this payment, but 40A1 disallowance was adverted to in the assessment order. In the regular assessment, the assessing officer disallowed certain payments under section 40A1A on the ground that tax was not deducted.
Now, so far as fee for technical services that is claimed as an expenditure by the company.
I have claimed an expenditure of subcontracting charges I paid to Infosys China. The officer feels that the nature of that payment
Is actually
fees for
to-
technical. And therefore, I ought to have deducted tax. And because I have not deducted tax, 40A1A disallowance has to be done.
So that payment to subcontract, the subcontract charges has passed scrutiny without any.
Without any risk. Now, because he receives information from another wing, a TDS wing, where a TDS 201 order was passed, saying that I ought to have deducted tax on these payments. Using that order, he says, I want to reopen this assessment. That format is not permissible. First of all, the officer himself borrowed satisfaction. Your Lordship must have seen the propositions generally that come up during the course of assessment. One is there can't be a change of opinion. Earlier there has to be reason. It can't be change of opinion because that amounts to review of the assessment. Then it cannot be the reason to believe has to be his own, not of some other officer. He cannot borrow satisfaction because some other officer said that these payments are in the nature of fees for technical services. He cannot reopen. I'm not getting into all that. I'm only saying that these reasons, in any case, don't allege that I have failed to disclose the material fact of the payment of this amount to Infosys.
Whether that payment is to be construed fee for technical services as contended by them is a legal understanding.
There is an inference drawn by him, and it is something that I am contesting. That 201 order and proceedings I am contesting.
So what is your stand? No, now whether this material that is stated by you is sufficient for.
I passed on the Bombay High Court order. Para 20, which very clearly says that when there is no allegation of non-disclosure, proceedings have to fall. Para 20, Malot, sir.
Para
20 at page 5.
just read.
The reasons recorded by the assessing officer nowhere state that there was failure on the part of the assessor to disclose fully and truly all material facts necessary for the assessment of that assessment. It is needless to mention that the reasons are required to delay as they were recorded by the assessing officer. No substitution or deletion is permissible. No additions can be made to those reasons. No inference can be allowed to be drawn based on reasons not recorded. It is for the assessing officer to disclose and open his mind to reasons recorded by him. He has to speak to his reasons. It is for the assessing officer to reach to the conclusion as to whether there was failure on the part of the assessing. Disclose fully and fully all material facts necessary for the assessment for the concerned assessment here. It is for the assessing officer to form his opinion. It is for him to put his opinion on record in black and white. The reasons recorded should be clear and unambiguous and should not suffer from any vagueness. The reasons recorded must expose his mind. Reasons are the manifestation of mind of the assessing officer. The reasons recorded should be self-explanatory and should not keep the assessing guessing for the reasons. Reasons provide link between conclusion and evidence. The reasons recorded must be based on evidence. The assessing officer, in the event of challenge to the reasons, must be able to justify the same based on material available on record. You must disclose in the reasons as to which fact or material was not disclosed by the SSP fully and truly necessary for assessment of that assessment year, so as to establish vital link between the reasons and evidence. That vital link is the safeguard against arbitrary reopening of concluded assessment. The reasons recorded by the esteemed officer cannot be supplemented by filing affidavit or making oral submission. Otherwise, the reasons which were lacking in the material particulars get supplemented by the time the matter reaches the court on the strength of affidavit or oral submission settlement. This is what Bombay High Court had said, and this was followed consistently by our High Court. Multiple decisions are just like one, my lord. The unit factors. My lord, kindly turn to page 6, para 5. My lord, sir.
This KP Kumar has stopped appearing.
He comes to the office for a couple of hours, stop coming to the court.
Paragraph?
Paragraph 5 at page 6.
Yes.
Sir,
Yes.
in the light of the aforesaid facts and the rival contenders, short point that arises for our consideration is whether the contents of the note, which is not in dispute, constitute fully disclosed material facts as required under law. The said note reads as under. These are reasons recorded in that case by the SC not there is no allegation. And is in para 6. From the note, it is clear that the SSC had a total interest of liable to tax out of the said amount. A sum of control is earned by STP unit. The STP unit was eligible for exemption under Section 10A. The case of the SSC is that even the interest amount earned by STP is eligible for exemption under Section 10A. Therefore, that portion of the interest amount was not offered to tax, and the remaining amount was offered to tax. Hence, we fail to understand what other material particulars the esteemed officer wanted in order to determine whether the said amount of rupees so is taxable or not. As rightly pointed out by the tribunal, the said note did disclose the full and true particulars, and the SSC has not suppressed or omitted to mention any particular which is required for obtaining of assessment. In this context, the aforesaid judgment of the Bombay High Court, in the case of Hindustan River Limited versus ACIT, assumes importance. It is observed in the said judgment that the reason recorded by the SC officer nowhere state that there was failure on the part of the SC to disclose fully and fully all material facts necessary for the assessment of that assessment here. It is for the SC officer to disclose and open his mind.
Now, just point out in the assessment order regarding this subcontract or in your returns, your declaration of this.
I'll point that out also. If my lord kindly turn to see page 25, which is the tax audit report, which was filed during the course of assessment. My lords have it. Page 25, annexure C. If my lord kindly turns to page 51. Page 51. There's a table, annexure A. That table, if my lords kindly see, Roman 4, payments to subsidiaries.
Yes.
Infosys China Software Development Services, 87 crores.
That is the same amount.
Same amount. I mean, it's rounded up to 87 crores. I'll point out the exact figure also, which is stated in Form 6CB. So this disclosure of payment to Infosys China has been made in the financial statements. And there's another form, 3CB, which I have filed. Is that what
So
my
this
lords
is-
are saying is a tax audit report, Form 3C.
So this is also filed along with your return.
Yes. And examined during the board's assessment. And if my lords kindly see the other form, that is form, which is Annexure F, page 61. This form 3CB, as my lords can see from the heading, is a report of chartered accountant under section 92E relating to international transactions. Now, in this report also have disclosed this payment at page 69. Page 69. The horizontal table.
Under what heading?
It is page 69. It says clause 10, appendix 3, particulars in respect of services.
Your page number, there is some,
This must be the one. What is there on this screen is the one. Infosys Technologies China Company Limited, software development, 8 crores, 86 crores, 51 lakh 99,000. Exactly. I mean, it's cut, I think. I'm not sure whether the full page has come. I'm not on this. Page 69. First page.
yes.
So they can't, in any case, even if he had alleged,
But this is the same amount.
same amount.
Yes. They have filed objection now.
They are fine. Mainly on merits, saying that these payment tax ought to have been deducted, it has not deducted, and 41 has not been done, and therefore the reopening is just.
Correct. So the other question will be, suppose on one ground you allowed it to pass. On one ground you allowed that expenditure to pass, and subsequently you discover that on some other ground you can you could have rejected it at that time. The assessing officer, it has passed scrutiny at the first instance.
Yes, sir.
So now he feels, no, on some other ground, actually, we should have disallowed it.
That we cannot do
No,
even within 4 years.
Correct. So that appears to be
Correct.
that.
Even that ground also we have taken in fact. We have said that this is actually a case of change of opinion. Because these payments were considered as part of my profits and gains, which I have claimed as deduction under section 10A, and my claim for 10A deduction has been allowed. And there was actually disturbances made under 40A1 for non-deduction of tax on certain payments. And there also the assessing officer did not make any disturbance as far as this amount is concerned. So therefore, it's also a case of change of opinion. Even within 4 years, this could not have been done. Now, after 4 years, in any case, it cannot be done. One, because there is no allegation in the reasons. And two, in fact, I have disclosed these material facts during the course of in my financial statements, and it has asked me at the first stages.
This is all on merits.
These all objections are mainly on that. fact, if my lords kindly see the assessment order, the regular assessment order under 143.
Yes,
Which is at page 74, annexure G. My lords have it.
yes,
Kindly turn to page 76. There's a transfer pricing adjustment done, which means that all my transactions with my associated enterprises, which necessarily includes my subsidiaries, and which are payments non-residents, have been subjected. That is para 2.2, transfer pricing adjustment. The international transactions or para 2.2.1, what's happened? The international transactions of the ST company with its subsidiary companies has been referred to the transfer pricing authorities by its letter dated so the transfer pricing officer has arrived at the letter.
we need not enter into this.
Yes. Because if I have to satisfy your lordship or change of opinion also.
Only on that ground. Sanmati is secretly telling Dilip to club it with that other China mat.
Incidentally, the department's appeal was order is not out yet, but department's appeal.
That is the petitioner. Has sought for setting aside of the proceedings under 147 with 148 as being barred by limitation and opposed to law and without jurisdiction, comma. Petitioner has also challenged validity of the preceding notice under 148 with 147 for the assessment year 2009-10 and the communication dated 26/9/2016 rejecting the petitioner's objections. Full stop. Senior counsel appearing for the petitioners submits that petitioner filed its return on 30th September 2009 for the assessment year 9-10 along with all other supporting documents. It is further borne out from the facts that now insofar as the assessment order on merits, there is an appeal. Correct. So there is an appeal.
Not the assessment order on merits. What they are saying is the 201 order, which was the basis for this reopening, 201 order saying I ought to have deducted tax. That the matter is in tribunal held in my favor. The department filed an appeal before the High Court. That also has been dismissed. No order. Order is not out.
Okay. Facts that on 29/3/2016, isn't it?
The date of 148.
Ah. 148 notice came to be issued. And in terms of the procedure prescribed under GK and drive shafts, the petitioner called upon the respondents for reasons recorded for reopening its assessment under 147. The respondent is stated to have addressed a letter disclosing reasons for reopening, copies of which are found at annexure K and L. Now that annexure K and L only is what you read out to me.
Annexure K is the reason.
Let annexure K and L. Annexure K. Next, learned senior counsel appearing for the petitioners draws attention to the contents of annexure K and submits that the reasons made out do not satisfy the requirements under the proviso to section 147, unamended 147. It is submitted that the period available under 147 was 4 years and the extended period was 4 years, that is till 31/3/2014, and if the extended period is to be availed of to justify issuing of the notice beyond 4 years, it is necessary that there must be a record of the SSC failing, inverted comma, to disclose fully and truly all material facts necessary for his assessment for that assessment year, close inverted comma. Next is also submitted that the material available for claim of deduction is the payment towards subcontract charges made to Messrs. Infosys China Private Limited. Such information is a part of the Form 3CEB.
Both Form 3CD, which is the tax audit report, and Form 3CEB, which is the international transactions that I had to discuss.
Form 3CEB as well as tax audit report in Form 3CD. Accordingly, it is submitted that once material was available before the assessing officer and assessment order is passed, the very same material cannot be a ground justifying reopening for the purpose of reassessment. Next. We heard both sides. Learned counsel for the revenue has relied on the contents of the statement of objections. Next. Third, senior counsel has relied on the judgment in the case of Hindustan Lever Limited versus RB Wadkar, 2004, 137 taxman, 479 Bombay. It's heard both sides. It must be noted that in terms of unamended section 147, proviso reads as follows. Next, the jurisdictional requirement leading to reopening of reassessment is a finding to be recorded that SSE has failed to disclose fully and truly all material facts necessary for his assessment. The perusal, huh? Which ought to be recorded in the reasons for reopening. Next. In the present case, it must be noted that, as rightly pointed out on behalf of the petitioner, the tax audit report in Form PCD points out to payment made to Infosys China for a sum of rupees 87 crores.
That amount is 86.
This page number
The form 3CD, color, CD page number is 51.
In the present case, it must be noted that as I pointed out on behalf of the petitioner, the tax audit form in Form 3CD. The jurisdiction requirement leading to reopening of the assessment is a finding to be recorded that the assessor has failed to disclose fully and fully all material facts necessary for his assessment, which ought to be recorded in the reasons for reopening.
No, but now what I'm saying, that material relating to this subcontract charges was declared. Now that material having been declared, that is subcontract.
The other point, you not to leave it open.
We argued in that other case. Next, peruse the judgment of the Bombay High Court in Hindustan Lever Limited, this RB Workers, and observations made at paragraph 20 are of relevance and reads as follows. The same has been noticed in the order passed in ITA 406 of 2007, called with ITA 407 of 2007, disposed of on 19 September 2011 by a division bench of this court. Next, the only point for consideration is to whether the reasons for reopening contained at Annexure K meet the jurisdictional requirements of the proviso under 147 within bracket unamended. Yes. The reasons do not have a whisper as regards to failure to disclose fully and truly all material facts. Next. In light of the contention of the made on behalf of the petitioner that the material facts relating to the amount of 86 lakhs 51,000, 86 crores 51,000, 99 lakhs 628 as subcontract charges being a part of the record, it cannot be stated that there is no disclosure fully and truly of all material facts. There is no failure to disclose fully and truly all material facts. Such factual assertion made is not controverted by the other side. Accordingly, on the sole ground that there is absence of a finding that there is a failure on part of the SSC to disclose fully and truly all material facts, the notice at annexure K is set aside and the petition is allowed. Though other contentions have been raised, same are not adverted to, as the petition could be disposed of on this jurisdictional point. Because tomorrow, in their audit, they'll say fit case for appeal. And then they'll contend. The learned judge has not applied his mind to the content, you will contend. Yes.
But the caution has to be noticed at annexure H. That is the 148 notice.
Yeah.
Annexure K is the reasons.
Accordingly, the notice at annexure H under 148 is set aside.
Right.
So under the old, under the earlier procedure, so first 148 notice, then you ask for reasons,
Before
then they
issuing that
communicate
notice, he has to record his the reasons in his file. That usually are not disclosed unless I ask for it by filing the written response to 148.
So after you ask for that, they give the reasons to you, then you file the return.
148 notice.
Correct.
Then I file a return and ask for reasons. Without filing the return,
Simultaneous.
you have to file the return to ask for reasons.
Simultaneous.
Yes, Supreme Court says unless you file a return, you can't even ask for reasons. So you have to necessarily file a return and then ask him to give the reasons behind issuing this 148 notice. Then he gives the reasons. Then the procedure laid down in GK and Reassessment, you file your objections to the reason questioning his jurisdiction.
Then he has to pass an order.
Dispose of by an order. It is 148 AD order now. That I can challenge it before your lordship. If I am aggrieved, if I am accepting it, then the proceedings will continue. We can proceed and pass a regular assessment. Right.
Yes. No, but what I'm saying, when you say fail to disclose facts truly, no, I'm just saying the position of law that should be in the context of the facts that is brought to the notice of the assessing officer. Now, suppose you declare, like in the previous matter, I have paid some subcontract charge. That is a factual assertion by you. Now, whether you're going to construe it to be FTS or otherwise is a legal aspect. What is required is material facts must be stated. That's all. So, yeah, you construing that he has not given full information, we need not enter into once the basic facts are given.
What are material facts? What are the inferences and response of that? The difference between material facts and the inferences.
Because it's very clear, it's a disclosure truly of material facts.
Page 6.
Yes.
The only question, what's that?
Yes.
The only question is whether income tax officer has recently believed that the captain's some condition of value to disclose in all value tax, except for the assessment or any of these years. The consequence under of which income assessment for consider the materials of the policy that the applicant has estimated should be the income tax. We can disclose the tax. Is necessary to examine the precise scope of disclosure which the section demands. Words used to have permission or failure to disclose anything or material facts necessary for the assessment for filing postulates a duty on every assessee to disclose fully and fully all material facts necessary for assessment. What facts are material and necessary for assessment are case to case. In every assessment proceedings, the assessing authority will, for the purpose of computing or determining the proper tax due from an assessee, required to know all the facts which contain in coming to the correct approval. On the primary facts in his position, whether on disclosure by the assessee are discovered by him on the basis of the facts disclosed or otherwise, the assessing authority has to draw inferences as regards certain other facts and ultimately from the primary facts. The primary facts for the front end, assessing authority has to draw the proper legal inferences, certainly on correct interpretation of the proper tax related. As when a question arises, whether certain income received by an SC is categorized or mistake, assessing authority has to find out what primary facts have been proved, what other facts can be inferred from them, and taking all these together to decide what legal inferences should be. They can be found out that the duty of disclosing all primary facts relevant to the decision of before the assessing officer lies on this. In the possible contention that there is some account books or other evidence has been provided, there is no duty of the assessing disclose further fact around due diligence the income tax officer might have discovered. The legislature has to make the explanation in the second law. View of the explanation, it will not be open to the SC to say, for example, I have used the account. You the SC officer determine that what these account books and the documents. Solution would be free. The assessing authorities attention to those particular items in the account books. All the particular portions of the documents which are relevant to level to the all the facts necessary for this. Not to give the context in characteristics. Yes, we will need to have disclosed other evidence which might have been discovered by the assessing authority. We had pursued investigation on the basis of what has been discovered. Explanation to the section gives a pointers to all such conditions, and the position remains that so far as primary facts are concerned, it is the SSC's duty to disclose all of them, including particular entries in account books, particular portions of documents, and other evidence have been discovered by the assessing authority. Other documents and other evidence is important. That's the duty, however, extend beyond the full and full disclosure of all primary facts. Our opinion, the answer to this question must be in the negative. Once all the primary facts are before the assessing party, he requires no further assistance by way of disclosure. It is for him to decide what inferences of facts can be reasonably drawn and what legal inferences are legitimately to be drawn. It is not for somebody else, obvious the assessing. Then the assessing authority, what inferences, other of facts or law should be drawn. Indeed, when it is remembered that people often differ as regards what inferences should be drawn from given facts, it will be meaningless to demand that the assessing must disclose what inferences, other of fact or law we should draw from the primary facts. If from primary facts, all inferences. Possible to say that if I draw multiple inference and communicated it to the assessment, how could an assessment be charged with failing to communicate an inference which he might or might not have?
Yes. Now suppose now in your return, you claim something as a revenue and claim a deduction. That is what you will assert because that's what you feel. It's for him to say, I no, it's not revenue, it is capital. Once you have shown it, there ends the matter. It's only material fact. Your perception is different. As long as that material fact is there, your perception is of no relevance. Yes. Hmm. The extended period. In this matter, 13? Yes. No, so, what is the date of notice?
Date of notice, my lord, is 31/3/21. Annexure F page.
It's in the extended period.
Yes, this is after 4 years,
So the time prescribed for the first 4 years will end on
31/3/2018.
So now you go to the reasons.
Reasons, my lord, will find it page 71. Annexure H. Audit scrutiny reveals that the SFE company had received capital effects, networking equipment and amounting to 51 lakhs, while note 23 of accounts, free of cost from Aspect US for rendering the service bid, and the SFE has neither added these effects to the fixed asset nor to the block of assets. However, the SFE has not added fixed assets received free of cost as income under section 28 of the Act. As per clause 4 of section 28, the value of any benefit of composite arising above on account of the business or exercise of profession, irrespective of whether it is convertible into money or not, was made chargeable to income tax under the head of business or profession. Therefore, it is not the actual receipt of money, but the receipt of a benefit of composite which has a monetary value, whether such benefit of convertible into money or not, are covered by section 28. The SSE had received a benefit in the nature of receipt of assets free of cost during the year, arising from business irrespective of the fact that whether the SSE had claimed depreciation or not. As per the notes to the account, very important, is relying on my account. As per the notes to the account, it is clearly mentioned that capital were received free of cost, free of charge by the SSE company from related concerns created abroad. Section 28(4) covers not the actual receipt of money, but the receipt of a benefit which has monetary value. Therefore, monetary benefit received by the company amounting to 51 lakh or is required to be disallowed under section 28 for the Income Tax Act. This mistake has resulted in short computation of life income with short levy of tax also including interest. So my lords will notice that there is no allegation here.
Correct. Now, what is this perquisite?
That is 28(4), my lord said it. Basically, it provides that where I receive any benefit of perquisite, although it may not be in the form of money, that has to be brought to pass. Section 28, my lord will find at page 1.244.
Yes, read.
Profits and gains of business or profession, that is the head under which the income is computed first. Section 28 starts with the following income shall be chargeable to income tax under the head profits and gains of business or profession. There, my lord, will see clause 4 on the next page, 1.246. That has been now amended, my lords, but before that, the portion before the italicized part, the value of any benefit or percentage, whether convertible into money or not, arising from business or the exercise of a profit.
That is the old one.
That is the old one. Now, also it is more or less the same, but it is more clarified. Now it reads the value of any benefit or percentage arising from business or the exercise of a profession, whether convertible into money or not, or in cash or in kind or
So what
partly
is
in cash and
correct?
partly.
So now what does he say here?
Now, basically, what he is saying is that I have received some free of cost assets from my associated enterprise. He is saying that that has to be taxed under 28 codes. The point, my lords, is one, he has not alleged that there is any non-disclosure on my part. But quite apart from that, this very issue, he himself examined during the scrutiny effort. And we see, my lords, the notice that he has issued during the original assessment. Before that, my lords, I will take my lords to the financial statements where this is disclosed. And he fixed it, in fact, from my annual report. Page 41, my lord.
It must be based on now, at least now, it must be information other than what is already on the
Yes,
page.
page 41 is my fixed asset schedule in the financial statement. It's a horizontal.
Yes.
There, my lord, this is the fixed asset schedule. Bottom of the schedule, my lord, is a note. The above assets do not include assets received, my lord. The above assets do not include the above assets does not include assets received free of cost from Aspect Software in USA, cumulatively amounting to 7.81 crores as at March 13. Previous year, 7.30 crores. So the difference, my lord, is 51 lakhs. So this year there has been an addition of 51 lakhs. So I have made a disclosure saying this is not included in my picture. Then, see, my lords, the notice that he issued to me during the scrutiny effort.
This is at earlier point of time.
At the time of 143.
143?
3 assessment.
Yes.
Page 51. The notice under 142.1. Dated 5/12/60.
Yes.
In connection with the scrutiny assessment proceeding under 143 of the IT Act for AY 1340, you are requested to furnish below mentioned details on or please explain why fixed assets received free of cost not be added as income under section 28 of the IT Act. Specific question on the same point. In fact, legal inferences also he has drawn. Kindly see annexure D, my response. Page 52. I give an explanation in detail.
Yes.
I will not trouble my lord with reading the entire thing, but maybe the first paragraph on page 6 under the heading treatment of assets free of cost of the books and income tax return of the subject year.
Yes.
During the subject year, the SSE has received capital assets like networking equipment, telecom equipment amounting to 51,21,069 free of cost from Aspect to it for rendering services to it. We would like to inform you that as these assets are received free of cost, the SSE has neither added these assets mentioned in the balance sheet, not the block of assets mentioned in clause 14 of tax audit report of the subject year, and accordingly has
does not claim any depreciation in the book or return of expense. The SSC is a captive service, a captive development center for aspect and the capital asset has been received free of cost from aspect itself for rendering the software development and IT enabled systems to support the global contract negotiated by aspect client. It may be noted that the entire business revenue of the SSC is from aspect US only. The SSC is not getting any benefit from the received capital asset as the same are being providing the solutions to aspect US only from whom the same has been received. Then I go on to explain why 28 4 should not be applied in my case. Essentially, my not the trust comes at page 5, where I summed it up. I basically said that this is in the nature of a capital receipt, not a revenue receipt, therefore 28 4 does not. The first bullet on page 55 minutes.
This is in detail, you have adverted to it earlier.
Yes, sir.
Yes.
Page 55, that first bullet I sum up. To sum up, unless it's a revenue receipt, it cannot be the nature of income, except in situation in which capital receipts are specifically included in the definition of income, such as 22, 24, 10, 15. And unless it is in the nature of income, it cannot be considered for taxation under 28(4). The reference to benefits which can be brought back under 28(4) for benefits arising from the business also indicates that such benefit must be a business receipt or a revenue receipt. Then I go on to rely on certain judicial precedents also. Therefore, clearly it is a debatable issue. Then kindly see my note, the assessment order.
So now, in the assessment order,
The assessment order, he does not specifically discuss this issue, but he confirms that he has seen all my response. Page 61, annex A.
yes.
Paragraph 2 minutes. In response to the notices, she told her an authorized representative of the company appeared from time to time and gave the support. The SSC company is in the business of IT enabled services providers. After the verification of the details and discussion made with the authorized representative of the SSC, the assessment is completed as under, and only an adjustment under section 90 is done, 28(4) is not. Therefore, obviously, he was convinced with my response.
So there ends the matter. And this, according to you, because of what you have stated in reply to the notice, that cannot be construed to be falling within the non-disclosure under the provision.
Not only that, like my senior was submitting, it's a case of change of opinion, because that very issue, he has raised a legal question asking why 28(4) can't apply. I have responded, and he's found an opinion.
Yes. But we may have to only mention that the proviso, when it says fail to disclose, must be read in context with what they have disclosed. So suppose, like in this case, they have disclosed it. Now suppose you don't disclose it regarding this free asset, then it will amount to proviso being attracted. So that non-disclosure must be in term. Provided you are not going to take it in appeal.
Not when the other question open. Yes, they take it to appeal, on that point, it is.
No, that's why, because he'll attack my order, saying non-application of mine, etc., etc. Yes. No, this that constitutional bench judgment is clear according. No, see, it only says failure to disclose material facts relating. So what is the material fact? Is that I have received some asset, and you have also issued a show cause, though I'm not going to enter into it. You issued a show cause notice regarding 28(4). They have also replied. In the reply, they have clearly adverted to So that in terms of Constitution bench judgment, the petitioner has sought for declaration that the proceedings initiated by the second respondent under 147 read with 148 and continued by the first respondent are barred by limitation and opposed to law, petitioner has challenged the notice at Annexure F issued under Section 148 of the Act for the assessment year 13-14, sought for setting aside of the order passed by the first respondent disposing the petitioner's objections as to jurisdiction. Full stop. Named counsel so and so appearing on behalf of the petitioner submits that the returns was filed for the year 2000.
April.
2000 assessment year 2013-14 and for the purpose of initiating reassessment proceedings under the unamended section 147. The period normally available was period of 4 years from the end of the relevant assessment year, which would end on 31/3/2018. He submitted that in the present case, as the notice under 148 was issued on 31/3/2021, the proviso under 147 of the unamended Act requires to be satisfied. And unless the authority were to demonstrate that there is a failure to disclose fully and truly all material facts, the power under 147 cannot be invoked. It is submitted that that upon request of the SSE, the reasons for reopening communicated found at page found at Annexure H do not fulfill the jurisdictional requirements as per the proviso under 147. It is further contended that the assessing officer has referred to the material placed before the SSE and has also recorded there was a mistake in the short computation of income, including interest. And accordingly, no grounds are made out for reopening on the basis of reasons contained at Annexure H. Reliance is placed on the judgment of the Bombay High Court in the case of Hindustan Lever Limited versus RB Vodka 2004 137 Taxman 479. There's also judgment of the division bench in ITA 406 of 2007 called with ITA 407 of 2007 disposed of on 19th September 2011. Next. the heard both sides. It is clear that as the notice is issued on 31/3/2021, as regards the financial assessment year of 13-14 and the extended period of 4 years to 6 years is sought. The requirement of the proviso under 147 is a jurisdictional requirement. Section 147 proviso 147 with proviso. First proviso reads as hereunder. In the present case, a perusal of the reasons for reopening communicated would reveal that the assessing authority was of the view that the receipt of free assets would not be covered by the, it's an exemption, is it?
Chargeable under 28.
Would be chargeable under 28 Roman 4. It must be noticed that there is no finding recorded relating to failure to disclose fully and truly all material facts. Though there is some reference in the said reasons relating to references to this very amount in the earlier material, as noted in the said reasons. However, without entering into such aspect as to whether the material was revealed, whether the material having been mentioned in the earlier proceedings would be sufficient or not, on the only ground that there is an absence of a finding that the SSC has failed to disclose fully and truly all material facts. The order notice under 148 dated 31/3/2021 is required to be set aside, and the consequent assessment order is passed, and the
order of my objection.
And the preliminary order
Annexure M, my lord.
at annexure M dated 2/3/2022 is required to be set aside. Accordingly, petition disposed of. No, but now these page 4.
In Bombay,
No, but there's a difference actually. None of these judgments specifically say that there's a jurisdictional requirement in the absence of which, without entering the merit, it has to go. What here in all the judgments, if you see, it's actually the facts of all the cases where that there was some disclosure. In the light of such disclosure, the courts actually have come to a finding that there was no failure to disclose fully and truly. That is how it must be construed. It is the only decision.
They don't enter into whether.
Correct, but this only, actually, this is the only judgment which talks of. Remember, the coordinate bench of this judgment of the court in the case of Memphis versus Deputy Commissioner of Income Tax and others, passed in WP 55355 of 2017, has observed at para 3B as follows. A 3B extract. Accordingly, the court has coordinate bench has indicated that in effect the finding that there is a failure on the part of the SSE to disclose fully and truly all material facts is a jurisdictional requirement for exercise of power under 148. Such view requires acceptance, more so in the present factual matters. And in the absence of such finding found in the reasons communicated to the petitioner, such power could not have been exercised at all. Next. As the petition is being disposed of on this jurisdictional point, other contentions raised by the SSE, including that there has been disclosure at an earlier point of time, are not, and accordingly, the proceedings for reassessment cannot be initiated on a different view of the same facts is a contention that is not entered in. Yes. Mhm. Same Narendra. Yeah. No. Yes. Serial number 50. List the matter in the orders list.
Lord, serial number 54. My lord, serial number 54.
Just one minute. I'll come back. Just wait. Yes. 40. No. Great, but you must file an application. correct. Now, what is the interim order passed?
The interim order was supposed to start on 18,000. Now, the work is to matter, so we did an update. And it comes to the right hand. There are two.
What is the value of the goods?
The compensation amount was possible 90 lakhs.
No, but you should not seek for extension when the goods are released, when it's in your hands. Must you not comply with it strictly? I mean, what's the sanctity in getting an undertaking from you and releasing to you? You can't, no, huh? No, that's your headache. That you can't, and nor can you please plead hardship when the gold, whatever has been handed over to you, and it is appreciated, and you have also enjoyed short-term or long-term capital gain. What? Huh? No, you give whatever it is and you file an application. Now, in case they give you, take it without prejudice to for further proceedings or whatever. You take whatever they give, doesn't amount to waiver of any of your rights. If they seek for extension, that I'll consider on its merits. We'll have it tomorrow, but you pay whatever that, and then you must find that is 50. He said, I heard. No. This is the matter tomorrow in the orders list. Now you please instruct your clients. Because we can't take it lightly. You have the benefit of release. So you also have to reciprocate, isn't it? Yes. Yes.
My lord, serial number 54.
Yes.
My lord, needs to be tagged along with writ petition 1154 of 2023. The matter was listed yesterday. This is with respect to demand raised 1154 of 2023, my lord.
Serial number 54.
Yes, my lord.
No, this serial number 54, along with WP 1154 of 2023.
Please.
Yes.
Serial number 44, my lords.
Yes.
It may be disposed of next week, my lords. Can it be posted on Thursday, my lords, next week?
Yeah. 40. Relist the matter on
22nd, my lords.
22nd.
Let's serial number 61 and 62 as well, my lords. It may be disposed of, my lords. It may be posted next Thursday itself, my lords. If it's possible, it can be posted in preliminary hearing, my lords.
So disposed of in say, is it covered? What is it?
No, my lords, it just has to go back, my lords. And 62 is just a petition and 119 to be.
No, now,
Yes, my lords.
what you do is you make out a memo for disposal
Okay, my lords.
and request to be posted in preliminary hearing
Okay, my lords.
and get an endorsement for Sanmati. Now,
Okay.
if
Yes,
if he's satisfied that it is, let him just receive that memo.
okay.
Then
Yes,
I will list it in the preliminary hearing list.
okay. I'll do that,
So-
my lords. Yes, my lords.
Wherever matters,
Yes, my lords.
with the respondent also feels could be disposed of,
Yes, my
you
lords.
move a memo, get the signature of the other side, then
Yes,
we'll have it in the preliminary hearing list.
Okay. Yes, my lords. Oblige, my lords.